Fantastic. Justice Page, we have we have the plaintiffs and the defendants here. We did a sound check earlier to make sure that everyone's sound and video were working. And we have our jurors here. So whenever you would like me to call the case, I am ready to call the case.
Thank you, Ms. Moses. I am ready. You may call the case.
Fantastic. Okay, well, this honorable court is now in session with Justice Roger Page presiding. Before the court today, we have the case of Saylor versus Jennings.
Are we ready for our opening statements?
Your Honor, before we begin, may the plaintiff offer some preliminary matters?
Certainly. You may proceed.
Your Honor, may I first introduce my team?
You may.
My name is Lauren Thacker, and I will be performing the direct examination of Dr. Cameron Cares and the cross-examination of Taylor Tarr, as well as delivering the opening statement.
Thank you.
Good evening, Your Honor. My name is Manasa Malcolm. I will be performing the direct examination of Ms. Avery Andrews and the cross-examination of the defendant, Mr. Drew Jennings.
Thank you.
Good evening, Your Honor. I'm Isis Cantrell. I will be performing the direct examination of Bryson Saylor, the cross-examination of Ryan French, as well as delivering the closing arguments. My co-counsel and I represent the firm Dewey, Suam & Howe.
Good evening, Your Honor. My name is Reese Miller, and I will be performing the role of Avery Andrews.
Good evening, Your Honor. My name is Abby Grace Keeter, and I will be performing the role of Dr. Cameron Cares.
Thank you.
Good evening, Your Honor. My name is Katie Day, and I will be performing the role of Bryson Saylor.
Thank you.
Your Honor, at this time, the plaintiff would like to offer the agreed upon rules and stipulations into evidence.
You may do so, Ms. Thacker.
Thank you, Your Honor. We would also like to emphasize a few of the rules to you. First of all, under Rule 16, witnesses are not to be sequestered constructively or literally. Additionally, Your Honor, because we are on a Zoom trial, we are aware that there's a possibility that technical difficulties may arise. This is addressed in Rule 9 of the mock trial rules, and we will further elaborate on this rule later on if it is necessary and if technical difficulties arise. And finally, Your Honor, we would like to make aware to you and the members of the jury that one of our witnesses has a tic disorder, which means she may move, make noises, or speak involuntarily. And we ask that the court does not withhold points from us because of this and be accommodating to repeating if necessary.
Certainly. Go ahead.
Thank you, Your Honor. No further preliminary matters on behalf of the plaintiff.
From the defense, Your Honor?
Yes, any preliminary matters for the defense? You may proceed.
Yes, Your Honor, but first, may we enter our appearances on the record today?
Certainly.
Good evening, Your Honor. My name is Joseph Bilardo, and today I'm joined by my co-counsel, Mr. Sam Meacham.
Good evening, Your Honor.
Good evening.
And Mr. Chandon Klimico.
Good evening, Your Honor.
Good evening.
And today, the three of us represent the defendant in today's proceeding, Mr. Drew Jennings. And we're also joined today by a timekeeper, Mr. Vichy Parikh. And you won't see or hear Mr. Parikh over the course of today's trial, but he'll be handling the technology aspects, timing the proceeding, and doing his best just to keep me and my co-counsel on track.
Very good.
Your Honor, just two brief preliminary matters. First, opposing counsel already entered the stipulations, so we'd like to pull those up at this time. And Mr. Parikh, could you highlight stipulation 12 for us? Your Honor, we'd just like to note for the record today that the nature and amount of damages, in other words, the extent of damages, will not be subject to argument in today as this trial has been bifurcated. The damages will be part of that other trial, and they will not be subject to any questions or testimony today.
All right.
And with that, Your Honor, we are ready to proceed.
All right. I believe we're ready for the opening statements when counsel is ready to proceed.
Yes, Your Honor. Motive, means, and opportunity. The perfect recipe for sabotage. May it please the court, opposing counsel, members of the jury. When Miss Bryson Saylor stepped into the defendant's restaurant to try a chicken sandwich, she was shocked when she took a bite of her meal and felt something sharp in her mouth. the secret ingredient to the defendant's recipe for sabotage, a 1-inch galvanized screw. We are here today because the defendant wrongfully put a screw in Miss Saylor's sandwich. Miss Saylor owns a self-made chicken business called Sailorman's. The defendant owns a new and opposing franchise restaurant, Eat More Chicken. The defendant was motivated to use any means necessary for an opportunity to sabotage Miss Saylor's business. Members of the jury, in today's case, we, on behalf of Miss Saylor, have the burden of proof, and we accept it. We must prove the elements of this case by a preponderance of the evidence. This means that we have to prove to you that it is more likely than not that the defendant intentionally, unlawfully, and harmfully caused offensive physical contact to our client. This is a mere tip in the scale, a tip caused by the weight of the defendant's special ingredient, a 1-inch galvanized screw. Today, the plaintiff will call 3 witnesses, each testifying to a different ingredient in the defendant's dangerous recipe. Motive. Miss Bryson Saylor, the plaintiff herself, will tell you of her unpleasant interactions with the defendant online. The defendant had previously tried to sabotage her business by posting lies about the ingredients in the food that Miss Saylor served. The defendant took the competition so seriously that he was motivated to do anything to make sure he is on top. Means. A former employee of Eat More Chicken will tell you that the defendant himself was adamant about serving Miss Saylor, and that she noticed the defendant with a toolbox while serving her. A toolbox that contained the means for sabotage, a screw that matched the one removed from Miss Saylor's stomach. Opportunity. To complete the recipe, Miss Saylor's doctor will testify to the opportunity that the defendant had to harm Miss Saylor and how the screw posed serious threats to Miss Saylor's business and her life. The doctor will tell you about the invasive procedures she had to use to remove the screw. After hearing the doctor's testimony, you will see the opportunity that the defendant had to sabotage Miss Saylor's health and her business. Members of the jury, be listening for these 3 ingredients: motive, means, and opportunity. They are all there. Sandwiched together, they create the perfect recipe for the defendant's sabotage of Miss Saylor's life and business. Pay careful attention to the defendant's special ingredient, a 1-inch galvanized screw. That screw sent Miss Saylor to the hospital. It could have caused massive damage to her internal organs. Even worse, it could have killed her. It's a miracle that she's still alive today. You'll hear from Miss Saylor about how this event has affected her. Her life will never be the same again, and all because of the defendant's recipe for sabotage. The defendant will try to mask this fact by calling 3 witnesses, but every single one of them will testify that the defendant was in complete control of Miss Saylor's sandwich the whole time. They're going to try and tell you some hypothetical situations and theories, but members of the jury, be listening carefully. What proof can the defendant offer, and what legitimate facts can they give you that prove their theory? Members of the jury, we are certain that by the end of this case, you will see that the defendant had all of the necessary ingredients for sabotage: motive, means, and opportunity. At the end of this trial, we ask you to find the defendant liable and award Miss Saylor damages. Thank you.
Thank you, Ms. Thacker. The defense may proceed with your opening statement.
Thank you, Your Honor. May it please the court, opposing counsel, members of the jury. Killing 2 birds with 1 stone. It's a saying I'm sure many of you are familiar with. It means to accomplish 2 goals with 1 action. 2 birds with 1 stone. And that's what this case is really all about. Someone attempted to harm 2 businesses by casting just 1 stone, or in this case, 1 screw. You see, the story Ms. Thacker just painted for you is the story of a victim and a culprit. Bryson Saylor, the owner of a local chicken restaurant, is the victim, while Drew Jennings, the owner of another local chicken restaurant, is the culprit, supposedly placing screws in his own restaurant's food. And look, Miss Thacker got it half right. Bryson Saylor is certainly a victim, most likely of an intentional battery. But as the evidence will show today, Drew Jennings is no culprit. Because when someone placed a screw in the food at Eat More Chicken, with Bryson Saylor's health and Drew Jennings' business were both under attack. Two birds with one screw. So some obvious questions. Was there someone who would want to harm both Bryson Saylor and Drew Jennings? Was that person present at the Eat More Chicken restaurant, and did that person have access to Bryson Saylor's chicken sandwich? Today, the answers to every one of those questions will be yes. A radical group of animal rights activists dead set on stopping the meat industry had targeted and harassed Miss Saylor for years, so much so that she'd even had them arrested by the police. And on September 5th of 2019, those same protesters were targeting my client's restaurant. But when Bryson Saylor arrived in the parking lot, those protesters were presented with two targets in one location. Two birds could attack with one screw. That's exactly what they did. An eyewitness from the parking lot will testify that he saw one of those protesters wearing a full chicken costume follow Bryson Saylor inside the restaurant. A protester who just moments later was seen alone with Bryson Saylor's chicken sandwich. Drew Jennings himself will testify that he briefly set the sandwich down on a table when he went to the back to get napkins. And when he returned, he saw that the bun of that sandwich had been slightly moved off. Unaware that both his business and Miss Saylor's health were both under attack, he simply fixed the bun and served the sandwich. And the rest is history. So given this logical explanation, the question becomes why? Why is the plaintiff suing my client instead of the protester who was alone with her food right before it got served? And the answer to that question is relatively simple. She's trying to save her business. Her own accountant will come before you and testify today to a 25% decrease in sales after Eat More Chicken had opened. And that same accountant will tell you that he had a conversation where Miss Saylor said she was going to put a stop to Drew Jennings' business, whatever it took. After that conversation happened, this lawsuit got filed. You see, the plaintiff's attorneys are asking you to believe that Bryson Saylor was part of a sabotage, that Drew Jennings sabotaged his own business, that Drew Jennings intentionally served a customer he had never even met before, a sandwich containing a metal screw, simply because that customer was a competitor. Luckily, it's not enough for the plaintiff's attorneys simply to accuse my client. Instead, they have a burden to prove it. They must prove their intentional battery claim today by a preponderance of the evidence, which they will fail to do. Because today, there will be no evidence that my client had any motive to harm Miss Saylor. There will be no evidence that my client sabotaged his own business, and there will certainly be no evidence today that Drew Jennings placed a screw in Bryson Saylor's chicken sandwich. Motive means an opportunity, a recipe for sabotage, a recipe with another person behind it, a recipe with a protester behind it, a recipe to sabotage two businesses with one screw, to kill two birds by casting a single screw. And that's why, at the end of today's trial, my co-counsel, Mr. Chandon Clemico, will ask you to realize that the protesters tried to kill two birds with one screw. We'll ask you to find in favor of the defendant. Thank you.
Thank you, Mr. Bellardo. We're ready with the plaintiff's proof now. You may call your first witness.
The plaintiff calls Avery Andrews. Please introduce yourself for the jury.
What is up, you guys? My name's Avery Andrews, but you might know me from my gamer tag, Big Clucky TN.
What do you do for a living, Miss Andrews?
Well, I am a professional gamer. It's pretty amazing, I know. I get to spend all day playing in tournaments and playing games, and that's how I make my living.
What is your prior employment, if any?
I used to work as a cashier at Eat More Chicken, which is the restaurant that Drew Jennings owns, but I don't work there anymore.
Why do you no longer work there?
I mean, I've always considered myself a professional gamer first, and after a few small disagreements in management, I realized that we weren't compatible and decided to leave.
You mentioned working at Miss Jennings' restaurant. Were you there the day of the incident, September 5th, 2019?
Yes, I was working the cash register that day.
What was it like?
I remember being pretty busy, but honestly, the restaurant was so busy all the time anyway that it was pretty normal.
Miss Andrews, what did you do at the start of your shift?
I just remember that I was working at the register when all of a sudden Bryson Saylor came into line.
Who is Bryson Saylor?
Bryson is Miss Jennings' main competitor. They own another chicken restaurant in the country, or not the country, the county.
And what happened after you noticed Miss Saylor?
I remember that Drew Jennings just instantly came over and told me to take a break, which I thought was kind of strange since I just started my shift.
When the defendant told you to take a break, what happened next?
I remember noticing that Drew seemed really angry and kind of nervous too, which was unusual.
Objection, Your Honor. This is speculation. The witness is speaking to the mindset of Drew Jennings.
Response, Your Honor.
Go ahead.
This is not speculation. The witness is rather describing the demeanor of the person at this instance. She's describing what she observed. And under Rule 701, lay witnesses are allowed to testify to their opinion, and Ms. Andrews is a lay witness.
I believe under 701, if you're testifying based on rational perception of the witness, it's allowed. I'm going to overrule the objection. You may proceed.
Yes, Your Honor.
Thank you, Your Honor. May I repeat my question?
You may.
Thank you. Ms. Andrews, when the defendant told you to take a break, what happened next?
Well, I remember Drew walks over, and then I just saw Drew seem very angry and nervous, which was definitely strange. And I even remember seeing Drew hold a toolbox, and I thought that was weird too, because who brings a toolbox to the register?
And once you went on your break, what happened, Ms. Andrews?
Well, I went to take a nap because I'd stayed up really late that night playing in a Fort Day tournament, so I thought I'd just catch up on sleep. But as soon as I started to fall asleep, I just heard this huge commotion.
And what was going on in the restaurant?
I mean, of course, I rush out to go see what's happening, and then I see Bryson Saylor just stumbling around in pain and screaming about swallowing something. I mean, honestly, I felt like I was in a horror game. It was terrible.
And what was the defendant doing during this time?
I really remember this part. So Bryson's leaving the restaurant in pain, and then Drew comes up to me and says, "It's about time that bully got what they deserved."
And Miss Andrews, why are you here today?
I mean, I'm here today because I used to work at the restaurant, and so I got called to speak. But I mean, honestly, I'm glad I don't work there anymore, so I can focus on gaming and not really be associated with that.
Thank you, Miss Andrews. No further questions at this moment, Your Honor.
You may cross-examine.
Ms. Andrews, like you said, you don't work at my client's restaurant anymore, do you?
No, I decided to leave after a few disagreements with management.
You say you decided to leave, but isn't it true that your employment ended directly after a disagreement with management?
It didn't end after a disagreement with management, but it was really just because I've always considered myself a professional gamer first, and I'd prioritize having Wi-Fi at home over showing up to work on time. But I really thought that if I got there in time for lunch rush, it was okay.
Exactly. You disagreed about whether losing internet at your home constituted a personal emergency, right?
Yes, and I really do agree with myself still. I mean, as a professional gamer, I know that having Wi-Fi is kind of one of the most important parts. And how am I supposed to stream on Twitch if I can't even get to the internet?
So you claimed it was an emergency because, like you said, it prevented you from playing video games, correct?
Yes, I mean, I think that's something very serious. I am a professional gamer. Again, gamer tags Big Clucky TN if you want to join my Twitch stream sometime after this.
But it is fair to say that Eat More Chicken didn't exactly see this as a serious inability to play video games as a reason to miss work, right?
Asked and answered.
Overrule, you may answer.
Could you repeat the question?
Of course, Miss Andrews. The Eat More Chicken management didn't see your inability to have internet and to play video games as a reason why you should miss work. Isn't that right?
No, they didn't. And I thought that was kind of strange because management always talks so much about pursuing your passions, but they wouldn't even support me to pursue mine.
You say it's strange, but you'd agree with me that when an employee fails to follow the rules, it's normal for an employer to get upset, right?
No, I mean, I don't know all too much about employing anyway. I mean, that's pretty much the only work experience I've had before this. But I mean, if I had someone helping me game, I wouldn't really mind. I kind of think breaking rules is a cool thing, as long as it doesn't hurt anybody, obviously.
So you wouldn't agree with me that when an employee is late to work, it's not a normal reaction for an employer to be upset?
Objection, Your Honor. Under Rule 402, relevance.
Response?
Your Honor. This goes directly to the bias that Ms. Andrews might hold against Eat More Chicken. Based on how she left management and how she left her employment, those could go directly to how she testifies in court.
All right. The objection's overruled. You may proceed.
Now, Ms. Andrews, you were formally reprimanded by your boss for arriving late to work. Isn't that true?
Not exactly. I mean, we had a meeting about it, but we still didn't agree that anything happened.
You didn't agree that anything happened, but you'd agree that you were formally reprimanded. And on that written statement, you both agreed that you were late to work, correct?
No, we didn't agree that I was late, but I did have a meeting with my boss.
But you do agree that you received a written warning from your boss, correct?
Yes, there was a warning, but again, I still didn't really agree that I was late anyway, so it didn't change much. And I mean, after that, I decided I didn't want to work there anyway.
You're telling this jury that you received a written warning for being late, but didn't actually agree to being late?
Mm-hmm. I mean, I've always thought that
Andrews?
if I get there on time for lunch rush, then I'm basically there when I need to be. I mean, I don't think many people order chicken sandwiches for breakfast, so.
Regardless of the exact circumstances, Ms. Andrews, you did receive a written warning from Mr. Jennings. That's yes?
Yes, I did.
And now you're testifying here against Mr. Jennings, correct?
Yes, but I've honestly not really had much against Drew Jennings. I was really kind of against my manager, Ryan French, because they were always on my case about being late, and they were just a total suck up to Drew, which I don't really know about all of that. I mean, Drew's a nice person, but I mean, to just get on to me constantly about being late. I mean, again, if I'm there on time for lunch rush, I don't even think it matters that much.
So you're testifying against the same person who, in your words, was constantly getting on you because you were late. Yes?
No, I'm not testifying specifically against Ryan French. I think I'm really testifying here about the day of the incident.
I'd like to talk about some things you told this jury about the day of the incident. You said a few minutes ago that Mr. Jennings seemed upset when he interacted with you. But isn't it true that you had arrived to work late that morning?
Yes, but really it wasn't even Drew who had talked to me. It was Ryan French who had gotten on to me about being late.
But Mr. Jennings was informed that you were late.
Not that I know of. I wasn't there when they were.
Well, Mr. Jennings gave you a written warning, correct?
Yes, but I don't know if that happened on the day of. We had the meeting about it on September 20th, which was later than this day.
Well, he signed that written warning, correct?
Yes.
Okay, Ms. Andrews, I'd like to talk about the toolbox you testified about earlier. You characterized it as odd that Mr. Jennings had a toolbox, but the truth is that there's a perfectly logical explanation for why that toolbox was there, correct?
Well, not exactly. I did see Drew hanging up pictures earlier, but they had plenty of time to take it back to their office. And I mean, really, if they hadn't been so adamant about serving Bryson specifically, they would have had plenty of time if I needed to take a break so badly.
Ms. Andrews, I'm going to ask that you just provide a yes or no answer for a few of these following questions, okay? Thank you. You admit Mr. Jennings was hanging photos in the lobby before he came to the cash register, correct?
Yes,
And you need tools to hang photos, right?
I suppose.
And when he arrived at the counter, you said he had a toolbox, but you never actually saw any tools in his hand once he arrived, correct?
No, I didn't see tools in their hand, but I still feel like having a toolbox kind of implies that you have tools with you.
But you never saw Mr. Jennings with a screw in his hand, correct?
No, but screws are very small. I doubt I would have noticed it anyway. It could have been in a pocket, maybe.
Could have been in a pocket, but you never even saw the toolbox open at the counter, did you?
No, but honestly, Drew told me to leave so fast to take a break that I didn't really have time to observe anything at all.
And you certainly never saw Mr. Jennings place a foreign object in anybody's food, right?
No, I was in the supply closet at that point, but again, bringing a toolbox to the register, being the person to serve them food, and then that person swallowing a screw later, it seems kind of suspicious to me.
So because Mr. Jennings had brought a closed toolbox to the counter, you were suspicious that he put a screw in his own customer's sandwich?
Yes, I mean, I feel like I've never brought a toolbox to the register. I've never had tools with me. I've never felt that necessary to serve people. And then, of course, after Drew Jennings does this, that's when they're found to have supposedly done this. It just seems so suspicious.
No further questions, Your Honor.
All right, thank you. Redirect examination.
Yes, Your Honor. Thank you. Miss Jennings, could you elaborate on why you did not see the exact scene go down?
Yes, again, I'd been working at the register and I'd pretty much just gotten to work. And then when Bryson Saylor got into line, that's when Drew Jennings told me to go take a break. And I went to take a nap in the supply closet.
Miss Jennings, Mr. Opposing counsel asked you a few questions about whether you saw Miss Jennings or the defendant with a screw or opening the toolbox. Did you see anyone else doing that?
No, I didn't. I really only got to pay attention to Drew and Bryson that day.
And what did you notice about the defendant when they asked you to take a break?
I remember Drew seeming really nervous and angry, which was definitely unusual for them. And again, the toolbox is pretty hard to miss.
Thank you, Ms. Andrews. Also in cross-examination, opposing counsel asked you some questions about why you were late that day to work. Could you briefly elaborate on this for us today?
Yes, I've been playing really late in a Fort Day tournament that night, and it was the kind where when you win, you just keep on playing, and I got kind of addicted to it, so I definitely overslept that morning.
Your Honor, may counsel screen share what has been pre-marked as Exhibit F for identification purposes?
Yes, you may.
Thank you, Your Honor. Thank you, co-counsel. Ms. Andrews, can you identify this?
Yes, this is the employee warning form I got from my boss, Drew Jennings.
Your Honor, at this time, I now offer Exhibit F into evidence as authenticity has been stipulated.
I object to hearsay, Your Honor.
Response, Your Honor, if I may.
You may.
This is not hearsay because the parties have Miss Andrews would have knowledge about this as she already testified to and is within the witness's knowledge, and it's not being offered for the truth of the matter asserted. Instead, is going to the credibility of the witness, and also this is a hearsay exception under Rule 803.6, as it is a business record.
Overruled. The objection's overruled. It will be admitted. You may proceed.
Thank you, Your Honor, and thank you, co-counsel. Let the record reflect co-counsel has stopped screen sharing. Ms. Andrews, could you tell us a little bit about that document you just saw?
Yes, so this happened a few weeks after the incident. I believe it says September 20th on it, and it also says that while we did meet about this, neither of us agreed that this happened. We just agreed that we had a discussion about me being late.
And why did you decide to leave Eat More Chicken, Ms. Andrews?
I mean, I really decided because of some small disagreements like this, but also because I just want to devote all of my time to gaming. I mean, I'd already been showing up late because I was gaming so much, and it was hard for me to really even think about anything else. I just wanted to play Fort Day and other games all day.
Thank you, Ms. Andrews. No further questions at this time.
Counsel, you may recross if you desire.
No recross, Your Honor.
All right, thank you. Plaintiffs may call the next witness.
Your Honor, the plaintiff calls Dr. Cameron Cares. May I proceed, Your Honor?
You may.
Hello, Dr. Cares. Before I begin, can you see and hear me well?
Yes, I can.
Could you please introduce yourself?
Hello, my name is Dr. Cameron Cares.
And where are you from?
I'm from Boston originally.
Do you have a curriculum vitae, Dr. Cares?
I do.
And would you be able to recognize a copy of it if it were presented to you today?
Yes, I would.
Your Honor, may my co-counsel screen share what has been pre-marked as Exhibit A for identification purposes?
Certainly.
Dr. Cares, could you identify this document?
Yes, this is my CV.
And is it an accurate reflection of your educational background and employment experience?
It is.
Do you adopt it as part of your sworn testimony?
I do.
Your Honor, at this time, I would like to offer Exhibit A into evidence. Its authenticity has been stipulated.
Not hearing an objection, it will be admitted.
Without objection.
Okay.
Yes, Your Honor. Thank you, co-counsel. Let the record reflect that my co-counsel has stopped screen sharing. Dr. Cares, could you tell us a little bit about your educational background as contained in your CV?
Of course. So to become a doctor, you basically have to go through 4 levels of schooling. So regular undergrad college, your internship, your residency, and then your fellowship. So I went to undergrad at Tufts University and then went to medical school at Boston. And then I moved to New York where I did my internship and my internship at Beth Israel and my fellowship at Rochester.
And Dr. Cares, what has your employment experience been like?
So after Rochester, I decided to stay in New York, where I did private practice for about 9 to 10 years. And then I got really sick of the cold and the loud streets and the craziness of the North. So I decided to move down south, where I've been working at Poultry County Hospital for the past 15 years.
And what is your job at Poultry County Hospital?
I'm their gastroenterologist.
What does a gastroenterologist do?
So gastroenterology is basically just the digestive system. So from when it enters to when it exits and everything in between is our department.
Your Honor, at this time, I would like to tender Dr. Cameron Cares as an expert in medicine with a subspecialty in gastroenterology. Per Rule 702, a proper foundation has been laid.
Response?
I have no objection, Your Honor.
So ordered.
Thank you, Your Honor. Dr. Cares, let's shift your attention to the day of September 5th, 2019. What were you doing that day?
So I was waiting in the ER. I was on call at the ER's on-call gastroenterologist.
And do you know Miss Bryson Saylor?
I do. I was paged to the ER when she came in complaining of abdominal pain.
And how did you proceed after learning that she was having pain?
So I immediately ordered an x-ray to try to figure out what was going on.
Your Honor, may my co-counsel screen share what has been previously marked as Exhibit E for identification purposes?
Yes, you may.
Dr. Cares, could you please identify this document?
This is the x-ray that I ordered.
Your Honor, at this time, I offer Exhibit E into evidence. Its authenticity has been stipulated.
Without objection, it will be entered.
Yes, Your Honor. Dr. Cares, what did this x-ray tell you about Miss Bryson Saylor?
So this showed us that the cause of her abdominal pain was a 1-inch screw that was lodged in her lower left abdominal quadrant of her stomach.
Thank you, co-counsel. Let the record reflect that we have stopped screen sharing. Dr. Cares, how did you proceed after making this diagnosis?
So I immediately ordered for an emergency endoscopic foreign body removal.
Could you tell us a little more about the process of an endoscopic foreign body removal?
Of course. So that's where we have to put the patient under a local anesthetic. So their gag reflex doesn't hurt us because we have to take a long scope and force it down the patient's throat. And it has a clamp on the end of it that we use to try to grab the foreign object out of their body before it is digested more so we can avoid major surgery. It is still, unfortunately, an invasive procedure.
And Dr. Cares, was your procedure successful?
Thankfully, it was. We were able to get to the screw in time before it caused damage and continued being digested.
And would you recognize a photograph of this screw if it were provided to you today?
I would.
Your Honor, may my co-counsel screen share what has been previously marked as Exhibit C for identification purposes?
Yes, you may proceed with that.
Dr. Cares, could you please identify this document?
Yes, this is in fact the screw that I removed.
Your Honor, at this time, I offer Exhibit C into evidence. Its authenticity has been stipulated.
It'll be admitted.
Yes, Your Honor. Dr. Cares, what kind of screw was this?
When we pulled it out, we saw it was in fact a 1-inch galvanized screw.
Thank you, co-counsel. Let the record reflect that we have stopped screen sharing. And Dr. Cares, in your expert medical opinion, what was the opportunity that the screw had to harm Miss Saylor?
Objection, Your Honor. Per Stipulation 12, this trial has previously been bifurcated, and during this here liability phase of the trial, damages and injuries are not an issue. That is for a later date.
May I respond, Your Honor?
You may.
Your Honor, damages are not the same thing as injuries. Damages refer to the monetary value that the plaintiff is requesting from the defendant's liability for battery, whereas we're going to the injuries and the harm that Miss Saylor was faced with when swallowing a screw. So what my opposing counsel is objecting to is the discussion of the monetary damages, and what Dr. Cares is testifying to is the injuries that Miss Saylor faced, which she would have knowledge of as her doctor and as an expert in medicine with a subspecialty in gastroenterology.
May I respond?
Briefly.
Your Honor, we agree that damages may involve money, but it's not limited to that. There are also my apologies, emotional damages, injurious damages. In addition, even if Ms. Thacker's correct that damages only refers to money, this testimony is still not relevant to determining Drew Jennings' liability for this battery.
Well, it is bifurcated in this hearing today. We're doing fault and then damages, so I'm going to sustain the objection.
Yes, Your Honor. Dr. Kears, what was the harm that Miss Saylor faced from swallowing this screw?
So besides the severe pain she experienced originally before we were able to remove it, the scope itself that we used for the emergency foreign body removal is just barely smaller than the esophagus. So it can be painful and damaging to the lining of the esophagus.
Your Honor, I renew my objection. I believe you've already ruled that this testimony about injury is not admissible.
Sustain. Go ahead.
Dr. Kears, how did you proceed after removing the screw?
So after we removed the screw, I decided to perform an EGD, or an esophagogastroduodenoscopy. And this is a similar procedure to the foreign body removal in that we take, again, a long scope, this one with a light and a camera on the end of it, and force it down the patient's throat to look around the inner linings of the esophagus and stomach for any damages we can't see.
And Dr. Kears, what did you do after completing the EGD?
So after completing the EGD, I was originally prepared to discharge Miss Saylor, but then she began experiencing more pain and anxiety about the incident.
Objection, Your Honor. Again, stipulation 12.
Response.
Your Honor, an element of battery is that we have to prove that Miss Saylor's ingestion of a screw was harmful, and we're doing that by proving that she was physically injured or had emotional injuries from that, and that it was harmful to her emotionally. So this is part of our burden of the plaintiff to prove that it was harmful.
All right, I'm going to allow it. You may proceed.
Thank you, Your Honor. May I re-ask my question?
You may.
And Dr. Kears, what did you do after completing the EGD?
So like I said, I was prepared to discharge her before she began experiencing more pain and anxiety about the incident. And so I decided to keep her overnight just in case there was some damage we couldn't see or our machines had missed.
And have you seen Miss Saylor since her initial visit to the hospital?
I have. She has come back for an appointment 4 more times. Again, experiencing pain and anxiety. So I have run more EGDs to try to find any damage, but unfortunately they are inconclusive as our machinery is really old and outdated.
Thank you, Dr. Kears. No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Now, Dr. Kears, I'd like to begin with a couple things we can all agree about. We can all agree there was a screw in Bryson Saylor's stomach, correct?
Of course, that's what our x-ray showed, and when we removed it, that also made it very clear.
Exactly. No one's disputing that. But you're aware Miss Saylor claims to have swallowed that screw while eating a chicken sandwich, correct?
That is what I've been told, yes.
Well, it's this jury's job to determine how that screw got onto the sandwich. But you have no medical evidence that can help the jury make that determination, do you?
Well, I don't have the medical evidence to tell you how it got in there. I'm more concerned with Miss Saylor's well-being and getting the screw out before it caused any further damage to her. And it has already caused severe psychological damage, I suspect.
You certainly have no evidence about who put a screw in that sandwich, right?
No, I'm really not concerned about that as much as I'm concerned about my patient and her well-being.
You can't even tell this jury whether the screw was on a sandwich or not, correct?
Objection, Your Honor. This witness, first of all, under Rule 602, has a lack of personal knowledge about it. She was not present for Miss Saylor's ingestion of the sandwich, and her field of expertise does not have anything to do with investigating how a screw was ingested. Additionally, it's irrelevant to the testimony because Dr. Kears is here to testify to damages and her proceedings and what she found as a doctor, and not the evidence or lack thereof that she found regarding how the screw was ingested or who put the screw in the sandwich. That is not really relevant on this witness's testimony.
May respond.
Yes, Your Honor. With regard to the lack of personal knowledge, it's certainly possible Dr. Kears has no personal knowledge of liability. That's kind of what I'm getting at. And I certainly don't want her to answer to anything she lacks personal knowledge of. But if Dr. Kears is solely here for damages, none of that testimony is relevant today. And what I'm trying to elicit from Dr. Kears is that she can't speak to the liability of the defendant, which is the issue of today's case.
The objection will be overruled. You may proceed.
Dr. Kears, you can't tell this jury if there even was a screw in the sandwich, correct?
I don't know if there was necessarily a screw in the sandwich, but I do know there was a screw in her stomach, and I had to remove it before it caused damage.
Now, Mr. Parikh, can we please pull up Exhibit E? It's already in evidence, Your Honor. Now, Dr. Karras, you just told the jury a lot about this X-ray. Nothing about this X-ray can help the jury determine who put a screw in the sandwich or even how it got there, correct?
No, the X-ray is just there to show that there was a screw and that it could have easily caused damage, and it helped us to identify what was going on and what our next steps were for her treatment.
And just to be clear, you offer no medical opinion at all about who put a screw in the sandwich.
Objection,
Isn't
Your
that right?
Honor. This has been asked and answered multiple times. Dr. Karras has clearly testified that she does not know how this screw was put into the sandwich, and I would ask under Rule 611A, opposing counsel stop badgering my witness on this issue as she's provided a clear answer.
I'm not sure that's badgering, but it has been asked and answered, so we'll move on.
Yes, Your Honor. Well, Dr. Karras, since you can't offer an opinion about how the screw got in the sandwich, I guess I'm confused about why you're here testifying on behalf of a patient. Haven't you stopped caring about your patients?
I've never stopped caring about my patients. My entire job revolves around them and their well-being. I will never stop caring about patients. I'm here because I was subpoenaed by the court to testify, in my medical opinion, what happened to Miss Saylor and what my proceedings were upon discovering that there was a screw in her stomach.
Well, you'll at least admit that you stopped caring about your current job, correct?
No, that is not correct.
It's your testimony that you didn't stop caring about your job?
No, I love my job. I've gotten into a nice routine in Poultry County Hospital, and I love seeing patients every day.
Dr. Karras, you remember giving a sworn statement, don't you?
I do.
You'd recognize that statement if you saw it here today?
Yes, I would.
Mr. Parikh, can we get Dr. Karras' statement on the screen? This is your statement, correct?
It is correct.
That's your name at the top?
Yes, that is correct.
And you were under oath when you gave this statement, weren't you?
That is also correct.
Well, Dr. Karras, we're going to enlarge a portion of your statement, and I'll ask that you please do read silently as I read aloud. I've applied for jobs in big cities like Jackson, Columbia, or even Kingsport, but no one will even give me an interview, period. So I stopped caring. I show up to work, I see my patients, I give them prescriptions when half of them probably just need Pepto-Bismol and a Sprite, but at least it keeps them from whining.
Your Honor, I would ask that the second half of the affidavit is unfairly prejudicial under Rule 403. And additionally, this is improper procedure for impeaching the witness on that statement as she's not been given an opportunity to contradict it. So while I understand why my opposing counsel may want to question Dr. Karras on the first part of it, I would ask that the line following "so I stopped caring, I showed up to work" be taken out of this current part of the testimony for the jury to hear and stricken from the record.
Response?
Yes, Your Honor. The second part of the statement gives context to the "so I stopped caring," and holistically, the doctor's testimony about not stopping caring about her job and her patients is rebutted by her previous statement, all of which is highlighted.
All right, the objection will be overruled. I think this is fair cross-examination. You may proceed.
Dr. Karras, I did read your words correctly, right?
Yes, you are correct, but I stopped caring is referring to trying to find a new job interview. I've settled into Poultry County and I've started to really like it here. I like my routine.
Well, you say you still care about your job, yet you give your patients unnecessary prescriptions to keep them from whining? That's your testimony?
Yes, those prescriptions aren't any stronger than Pepto-Bismol and Sprite. They just give the patients a feeling of being understood and listened to. Because a lot of times with medical jargon and tests and big issues, they don't feel like they're being heard as much. So by giving them prescriptions, even if they're not very strong ones, it gives them a sense of comfort that we're actually listening to them and that we are paying attention to their issues and they're not just being brushed off.
So Dr. Karras, I'm hearing you correctly. When you said I stopped caring, you're referring to stopping caring about finding new jobs, correct?
That is correct. Like I said, I've settled down into Poultry County and I like it.
And you've been unable to even get to the interview stage for other jobs, correct?
That is correct, but it doesn't matter to me anymore. I like it in Poultry County.
Your Honor, I'll take away my objection since the witness has already answered.
All right. I don't know if it's happening to everybody else, but I feel like I'm on Hollywood Squares here. Everybody's moving around on my screen. I hope it's not happening to everyone else. Go ahead.
Yes, Your Honor. Now, Dr. Cares, since you can't find any other jobs, that makes you care deeply about keeping your current one, correct?
Well, I'd always cared deeply about keeping my current job. That hasn't, not being able to get jobs in other places hasn't affected that.
And because of that, you don't want to upset your employer, correct?
Well, who would want to upset their employer?
But the plaintiff, Miss Bryson Saylor, she's on the board of directors at the hospital you work for, correct?
That is correct. It's really nice of her. She really cares about her community and giving back. So I really appreciate her being on the board and donating.
And you're aware Miss Saylor's here in the virtual courtroom today listening to your testimony, correct?
I'm aware of that, yes.
You don't want to upset a member of your hospital's board of directors because you can't find another job, correct?
Well, I don't want to upset her because I don't want to upset people, but I'm not going to base my testimony off of what she thinks. I'm here to be honest and tell the truth about what happened.
Dr. Karras, you weren't present at the Eat More Chicken on September 5th, 2019, were you?
Like I previously stated, no, I was not.
So you have no personal knowledge of what happened there that day, correct?
I do not.
So it's my co-counsel and my client's theory of the case that one of the protesters present at the restaurant that day placed a screw in Bryson Saylor's sandwich.
Objection.
Given that you're in...
This is
Go
again,
ahead, Ms.
this is a
Go
lack
ahead.
of personal knowledge under Rule 602 because this witness was not present at the restaurant that day, so they can't really be asked to. The opposing counsel has just established that they weren't present there that day, so this is irrelevant to this doctor, and they don't know about it. Additionally, the attorney has been testifying and asking a long question on cross without giving my witness the chance to respond.
All right, let me take those one at a time. Did you say you wanted to respond?
Yes, Your Honor. Would you like me to respond one at a time?
Well, let's just make it very brief. I think we've ridden this horse quite a bit already.
Yes, Your Honor. With regard to the personal knowledge objection, I don't want Dr. Karras to testify to anything she lacks knowledge of. I'm just ensuring that she doesn't have knowledge of a situation, not asking her to speculate. With
All
regard
right,
to
I'll sustain that part. You've already covered it. Second part.
the second part being the question of, my apologies. The second part of the objection was what, Ms. Thacker?
I also objected to relevance.
Okay, well,
Yes,
I've
Your Honor.
already sustained the objection, so let's move on.
Yes, Your Honor. One final question, Dr. Karras. You can't tell this jury that it was Drew Jennings who did anything to that sandwich, correct?
As I previously stated, I cannot tell you who did anything to what sandwich. I can just tell you that there was a screw lodged in Miss Saylor's stomach that I had to remove emergently before it caused damage.
Thank you, Doctor. Nothing further.
Ms. Thacker,
Yes, Your Honor. May I have a brief redirect?
you may.
Dr. Cares, what did you use to form the basis of all of your opinions?
I used medical information. I followed all the tests I took in my years of training as a doctor to create my opinions and perform my procedures to help Miss Saylor.
And would you allow Miss Saylor being a board member to influence your decisions?
Absolutely not. As a doctor, I took a Hippocratic oath to do no harm to my patients and to tell the truth on procedures.
Thank you, Dr. Cares. No further questions, Your Honor.
Any recross?
No, Your Honor.
All right, thank you. You may call your next witness.
The plaintiff calls Bryson Saylor. May I proceed, Your Honor?
You may.
All right. Good evening, Miss Saylor. First of all, can you see and hear me all right?
Yes, I can.
There's a bit of feedback issue. Did you hear that as well? Or is it okay on your end?
I also heard it, but I don't know what caused it.
Oh, it appears to be fine now. All right, Miss Saylor, would you please introduce yourself?
My name is Bryson Saylor.
And what's your current occupation, Miss Saylor?
I'm the proud owner of Sailorman's Chicken Sandwich Restaurant in Poultry County, Tennessee.
And so how long have you been a small business owner in poultry?
A little over 20 years now, practically my whole life. I've been in the business so long that the people of poultry have even started calling me the Chicken King. And I've got to say I'm proud of how supportive they are of my restaurant.
Now, I'd like to talk about the weeks leading up to September 5th. What was your experience on social media like?
Well, I get most of my news from social media, so I'm on there fairly regularly. And in the weeks prior to the incident, I had noticed that there was this new account that was making a lot of noise on Twitter, at no1chickenfan1. They had started a new hashtag new chicken king, and were also spreading a lot of lies about my business, saying things about how we use processed chicken and inhumane practices, which is just not true. And they'd even gone so far as to direct message me.
And Miss Saylor, if I showed you those direct messages, would you be able to recognize them today?
Yes, I would.
All right. Let the record reflect that I am screen sharing what's been previously marked as Exhibit D. Now, Miss Saylor, can you recognize these?
Yes, these are my direct message conversations with at no1chickenfan1.
All right, Your Honor, we offer into evidence what has been pre-marked as Exhibit D. Its authenticity has been stipulated.
Without objection, Your Honor.
Okay, so ordered. It shall be marked.
All righty, Miss Saylor, let's talk about these messages. Why do you start the conversation?
Well, as I mentioned, this account was spreading a lot of misinformation about my restaurant, and I wanted to have a conversation with them about why I thought that they should stop that and that it was not polite. So I wanted to have a conversation with them about that.
And so how did the conversation proceed from there?
Well, they acted like they didn't know what I was talking about, which seemed a little bit odd to me, given that most of their content on Twitter was about my restaurant. So in an attempt to lighten the mood of the conversation and hopefully make them more open to having a serious discussion and honest discussion with me, I sent them this funny little gif of one cartoon slapping another because I thought it was funny, and a pun balk off like a chicken box, hoping that that would bring the conversation to a happier light. But then they sent me these weird messages about how they thought I was just jealous there was a new Chicken King in town and they were going to enjoy watching my chicken kingdom crumble, which struck me as a little odd.
Right. So other than odd, at the time, what were your thoughts about this exchange?
Well, when I read the messages, I didn't really think that much of them. They were just some weird messages online, but in hindsight, they do seem a bit more threatening.
All right. And Miss Saylor, can you identify the day that all of these messages were sent?
Yes, they were sent on September 4th.
All righty. Thank you. Let the record reflect that I have stopped screen sharing. And Miss Saylor, what happened after receiving these direct messages?
Well, after I received the last message, my accountant, Mr. Taylor Tarr, came in. We had scheduled a meeting for that day to go over the August financials at my restaurant.
And what did those numbers indicate?
Well, unfortunately, they were down nearly 25% from the previous month's financials, which was a little bit frustrating, but that is fairly regular for when a new business comes to town, especially a big chain restaurant like Eat More Chicken. And it was only the numbers for that month, so I wasn't too worried in the long run. My customers are pretty loyal and they tend to come back to my restaurant.
All right, so now let's talk about the next day, September 5th. Why'd you head on down to Eat More Chicken?
Well, I wanted to try their chicken sandwich so I could give my honest opinion of it and respond to the criticisms I'd received online.
Right, so let's talk about that visit to the defendant's restaurant. How would you describe the service you received?
It was odd. When I got to the front of the register of the line to order, Mr. Jennings came out of the back and told his cashier to take a break. And I thought that that was a little unusual. As a business owner myself, I know that I don't really have the time in my day to take the orders of my customers. That's why I have people like cashiers. And then once Mr. Jennings was taking my order, he was acting very over the top and saying all sorts of things about how he was going to make sure I got the hottest, freshest chicken sandwich and he would bring it to me personally. It seemed very unusual.
And other than that unusual encounter, will you tell us more about your dining experience at Eat More Chicken?
Well, after about 10 minutes, I finally got my food. I tried the fries. They were all right. I tried my iced tea. It was actually pretty good. And then I started on the chicken sandwich. And it looked just fine. But when I went to swallow that first bite, I felt something sharp go down my throat. And at first, I thought it must have been a chicken bone because chicken bones end up in chicken sandwiches sometimes. That's just a hazard of the business. But I've swallowed chicken bones before, and this was much too sharp and heavy to feel like a chicken bone, so I knew something must be wrong.
And so what happened after you swallowed that screw?
Well, I tried to wash it down with my iced tea, but that wasn't working, so I started yelling for help because my throat was hurting like crazy.
Right. And at the time, why did you not want the manager, Ryan French, to call 911?
I know that ambulances can take quite a while to get to the scene of an incident, and then they have to drive all the way back to the hospital. So since I knew I needed medical attention, I thought that the fastest way to get help for myself would be to drive myself to the hospital. I could still breathe even though my throat hurt, and as long as I can breathe, I can drive.
And so what happened when you actually got to the hospital?
Well, I went up to the desk at the emergency room and I told them that I'd swallowed something and that it felt like it was still stuck in my throat. So they took me back and had an x-ray taken, and they found a screw in my stomach.
So how did you feel leaving the hospital after that?
Well, I was a nervous wreck. They had to do all these
Your
procedures.
Honor, I renew my Mr. Meacham's objection to Stipulation 12. The witness is about to testify to the extent of damages, which you've already ruled is inadmissible today because the trial has been bifurcated, and we're only here to determine who placed the screw in the chicken sandwich. How she was feeling after she left the hospital is in no way relevant to this today.
Response, Your Honor?
Yes, you may.
All right. So part of or burden of proof is that we must prove harm. That's one of the elements of battery. And harm can extend to physical damages, emotional damages, and financial damages. We're going to prove all three today, and right now we're proving emotional damages as a result of this event. Additionally, Stipulation 14, which was the basis upon which opposing counsel objected to, is only the intentional infliction of emotional distress, not the actual emotional distress that Ms. Saylor felt.
May I respond to that briefly, Your Honor?
You may.
Your Honor, my objection was under Stipulation 12. And first off, just to respond to opposing counsel, we agree that they have to prove that there was some kind of a damage that occurred. But the witness has already stated that. She already stated she was in pain when she bit into the sandwich. But now they're delving into that extent of damage to saying she was in pain hours after this had occurred, which is inadmissible under Stipulation 12. And you've already ruled on that today.
All right, I'm going to allow this to briefly proceed, but let's not go too far into it. You may proceed.
Yes, Your Honor.
Of course, Your Honor. And so, Ms. Saylor, I'll restate my question. How did you feel leaving the hospital after all of that?
I was a nervous wreck. I was just so worried about how I would be able to be around chicken after that, because now every time I'm around chicken, I remember the feeling of that screw going down my throat, and I haven't been able to work since then. Every time I look at chicken, it makes me break down. I have all this anxiety that I never had before, and I haven't been able to work in over a year and a half.
Now, Ms. Saylor, you heard Ms. Andrews testify that the defendant had a toolbox at the register of Eat More Chicken. Is this normal practice at Saylorman's, your restaurant?
No, I keep any tools back in the office so that if there is a problem in the lobby, I can go get them, but they're safely away from all customers.
And now, Ms. Saylor, why did you file a lawsuit against the defendant?
I believe that Mr. Jennings put that screw in my chicken sandwich to hurt me. He is the only one who I thought had any opportunity to do so, as he did take my order and make my sandwich and bring it to me himself. And I would like for him to know that he can't get away with trying to hurt somebody just because they're a competitor.
So what is your intention in filing this lawsuit?
I would like for Mr. Jennings to know that it's not okay to hurt your customers just because maybe you don't like them. And I would like for the citizens of Poultry to feel safe in their ability to get a safe meal from any restaurant they choose when they go out to lunch.
Thank you, Ms. Saylor. No further questions, Your Honor.
You may cross-examine.
Yes, Your Honor. Now, I'd like to talk about something that you talked to Ms. Cantrell about on direct examination. You stated that when a new chain restaurant comes to town, it's common for your business to decrease by 25%, but it often recovers, right? You testified that was normal. Those are your own words.
It's not always by 25%, but it is usually a decrease, something like that. It could be a little more, a little less, but my business does tend to bounce back. My customers have been there for a long time, and I am a staple in our community.
All right, and you've been in the restaurant business for 20 years, right?
A little over that now, actually, yes. I'm a pretty good business owner myself.
So you'd agree with me, you're a good business owner, that reputation is important in the restaurant business, right?
It definitely can be. Some people care a lot about reputation. Other people don't really pay much attention to that besides maybe a Yelp review.
Well, you'd agree with me that good food, clean facilities, good service, those are the kind of things that are likely to impact a restaurant's reputation.
Objection, Your Honor. Your Honor, I would like to object under 602, lack of personal knowledge, 402, relevance, and 39, a lack of foundation. Mr. Bellardo, is that a correct pronunciation?
Yes, that's perfectly fine, Ms. Cantrell.
Yes, yes. He's asking hypothetical questions of my witness, of which no foundation has been laid. And obviously, since it is a hypothetical under 602, she would have no personal knowledge of it, and there's no foundational factual basis upon which for him to ask these questions, and therefore I would believe it is irrelevant under 402.
All right, Your Honor, I'll try to respond to every single one of Ms. Cantrell's objections, but please let me know if I miss any of them. So first, to the lack of personal knowledge. And now, I just asked the witness a few moments ago if she'd been in the restaurant business for 20 years, and she had. And she was testifying to her knowledge of that, as she stated that she was familiar, that reputation was important, things of that nature. And she's been in the restaurant business for 20 years. So she's perfectly able to testify to what's important. None of that dives into a specific piece of knowledge that would only be exclusive to Drew Jennings. Instead, that's common knowledge she would have based on her experience in the restaurant business. As to the relevance of this, Your Honor, I'm leading to the idea that we have in today's case, which is that it's illogical that Drew Jennings would have placed the screw in a sandwich at his own restaurant, because to do so would have hurt his public reputation, and by that same turn would have hurt his business. So he'd be committing self-sabotage. And finally, Your Honor, to lack of foundation, I believe I already responded to that above, but she already testified she's been in the restaurant business for 20 years and everything like that.
Your response is excellent, but I think it's probably better for a closing argument and not a response during objection. The objection will be sustained.
Yes, Your Honor. Would you like me to lay more foundation as to that? How would be the best way to go about that?
I've already overruled your objection. You may proceed, Ms. Cantrell.
Oh, yes, Your Honor.
Oh, I'm sorry, Mr. Bellardo. I'm sorry. Go ahead with your cross.
Sorry, Your Honor. I was confused. You said sustained. All right. Well, would you like me to re-ask my question, Ms. Saylor?
Yes, please.
So you'd agree with me that reputation is important in the restaurant business, right?
It does matter to some people. It matters to me as a business owner what other people do think of my business, but some people don't care as much about the reputation of a restaurant as long as the food's good.
And a good reputation generally leads to good sales in your experience, right?
Typically it does, but again, sometimes the quality of the food can outweigh the reputation of like the cleanliness of the lobby or something like that.
Of course, but at least having a bad reputation generally leads to poor sales, right?
Again, it depends on the situation. It can, sometimes it doesn't. Some people are willing to overlook a bad reputation if it's a restaurant they've been attending for a long time.
Let me ask you this. If a restaurant serves a customer food containing a foreign object and the public finds out about it, that would be the kind of thing that would damage a restaurant's reputation, right?
Objection. Your Honor, I would like to renew all three of my previous objections, 602, 402, and 39, as Mr. Bellardo is asking again a hypothetical.
Response, Your Honor, just very briefly.
That's not necessary. I will let you go ahead and respond to the question, Ms. Bryson.
Will you
Ms.
answer?
Saylor, I'm sorry.
Or would you like me to re-ask it for you?
Yes, please.
Of course, of course. So I was just asking you, if a restaurant serves a customer food containing a foreign object and the public finds out, that would be the kind of thing that would damage its reputation, correct?
It likely would, yes.
That would be the kind of thing that would be bad for business in your experience?
Depending on the customers, some people wouldn't care as much, but it might hurt the opinions of some customers.
And yet your claim in today's case is that Drew Jennings did exactly that he intentionally placed a screw in your chicken sandwich and thereby intentionally sabotaged his own business. That's what you want this jury to believe?
Objection. Your Honor, this question is argumentative as opposing counsel is attempting to get my witness to agree with his conclusions.
Overrule, you may answer.
Yes, that is what I'm telling you happened. I don't think that Mr. Jennings completely thought through his action of putting that screw in my sandwich, but I think that in some sort of fit of anger, he did try to lash out at me without considering the repercussions this would have for his business.
So you're saying he sabotaged his own business, just to be clear?
I think that he wasn't considering how it would impact his business. It's possible that that does have a negative impact on his restaurant, but I don't think that that was what was going through his mind when he did it.
Well, to be clear, you never saw Drew Jennings place a screw in your sandwich, right?
No, you don't watch the preparation of your food at a fast food restaurant.
Of course, and I read the answer, I read the complaint in today's case, and you said that Drew Jennings acted with malicious intent, but to be clear, you describe him as friendly on the day in question, right? Those are your own words.
His words were friendly, but I don't know if you've ever been in a situation where someone says something nice, but their eyes convey a different intent. It was a similar situation to that. Everything he said sounded perfectly civil, but his mannerisms in saying it put me on edge.
You're saying that he had specific mannerisms in serving you your food that put you on edge. That's your testimony today?
Yes, malicious mannerisms.
Do you remember giving a witness statement?
Yes, I do.
And in that witness statement, you swore to tell the truth, the whole truth, and nothing but the truth.
Yes.
You were told to include everything of relevance to today's case in that witness statement, correct?
Yes, I was.
You were under oath when you gave the statement, just like you're under oath now.
That's correct.
Mr. Parikh, can we get that statement on the screen, please? Now, nowhere in this witness statement do you ever say that Drew Jennings had any malicious mannerisms when dealing with you on the day in question, correct?
I actually don't remember everything that I included in this statement. I wrote it well over a year and a half ago. I'm sure that there's something about it in there. However, unless I was given time to read the entire statement, I would not be able to confirm whether there is an absence of that information.
Well, you'd agree with me that you had up until today to look at this statement, right?
Yes, but I wasn't memorizing a statement I gave. I know what happened, so I'm able to testify based on my memory.
Well, Mr. Parikh, let's just briefly go to where it would contain that information. I believe that's the bottom of the first page and the top of the second page, where the witness talks about how she interacted with Drew Jennings. And let's highlight the words "too friendly," if possible. I believe that is on the second page, right at the top. And can we zoom in there, Mr. Parikh, by any chance? Now, I want you to read along silently as I read aloud. Drew Jennings was almost too friendly. How may I serve you? I'll make sure your sandwich is extra hot and fresh. My pleasure, blah, blah, blah. Those are your words, correct?
Well, you did throw in an extra word, and I was not able to read the first part of the sentence. But yes, that is for the most part what I was saying. And again, that's what I was referring to. He was acting too friendly, but the way that it was going felt malicious.
But you didn't put that in your statement even once, right?
No, I had already included it in my complaint.
And you had no disagreement or conflict with Drew Jennings inside Eat More Chicken, right?
Aside from the part where he put a screw in my sandwich, no, he did not.
Objection, Your Honor, to a lack of personal knowledge. The witness previously testified that she never saw him place a screw in her sandwich. Furthermore, we've heard from no witnesses who will testify or who did testify to that today, and therefore that's a lack of personal knowledge.
Well, that's the burden that the plaintiff has, is to prove that your client put the screw in the sandwich. So I will not strike it from the record. Just move ahead.
Of course, Your Honor, you did have a disagreement and conflict with another group present in Eat More Chicken, right?
I have no idea who all was present at Eat More Chicken that day.
Well, there was a group of protesters who you knew because they'd specifically protested at your restaurant in the past, right?
There were protesters at the restaurant that day, yes.
And you're familiar with these protesters because you actually had their leader arrested for harassment.
Objection. Your Honor, under 404B, I would like to request a bench conference really quickly.
I think we're going to do it in front of everybody, but go ahead.
A constructive bench conference, so it's constructively out of the jury's ears, if you don't mind.
Go ahead.
Thank you. Under 404B, my opposing counsel is attempting to establish character evidence of Miss Saylor in order to establish that she would act maliciously against people who threaten her business. And again, under 404B, that is not admissible. Its prejudicial value is significantly outweighs any probative value that could come from asking about Miss Saylor calling the police against these protesters.
May I briefly respond, Your Honor?
You may.
Your Honor, we're not using it for that at all. Rather, we're using it to show that there was a negative relationship between these protesters and Bryson Saylor. That negative relationship makes it more likely that those protesters would have a motive to want to go after Ms. Saylor, as is our contention today.
Response, Your Honor?
Yes.
All right. Stipulation 7 states that teams may not assert any defense against any non-party person or entity. Your Honor, a non-party defense is comparative fault doctrine, and Stipulation 7 states that we can't assert any defense against non-parties.
Your Honor, may I respond to that, which is an entirely different objection?
Go ahead.
Your Honor, opposing counsel is entirely misrepresenting what Stipulation 7 says. In fact, the people running this competition changed that stipulation for the precise reason because this stipulation was misinterpreted. Stipulation 7, if I may read it, Your Honor, and actually, could we get that stipulation on the screen, please, in its updated form? Your Honor, the highlighted portion, teams may, however, question witnesses called during the proceedings to establish motive, opportunity, and intent for persons other than the defendant if such questioning is consistent with the information contained within such witness's statement provided. And today, that information is contained in that statement. Furthermore, Your Honor, we are going to question witnesses about this because we are establishing there was a motive, opportunity, and intent for the protester to place a screw in Bryson Saylor's chicken sandwich. Stipulation 7 absolutely says that we're allowed to do that and in no way precludes us from asserting a defense in today's case.
Your Honor, if I may respond.
Briefly.
Your Honor, opposing counsel may question witnesses in order to create doubt concerning comparative fault, but they cannot declare comparative fault. They are going far beyond just questioning witnesses in order to create doubt. They are asserting their entire defense, as stated in their opening arguments. Additionally, they are trying to establish a comparative fault, which they simply cannot do under Stipulation 7, Your Honor. It has been updated. However, it still reads that teams may not assert any defense against any non-party person or entity.
All right. Those are very good arguments. I'm going to overrule the objection. I don't believe 404B applies here, and it goes to motive. Go ahead.
All right, now I've just got a few final questions for you with the last couple seconds we have. And now you actually recognize the protesters because they've protested at your restaurant in the past, correct?
Yes, quite a few years ago, they did protest at my restaurant, and I am in full support of that. I do support their right to protest. However, one of them was harassing my customers, and I received requests to have that protester in particular removed. But that was quite a few years ago, and we haven't had any problems since then.
So here's my final question. If these protesters wanted to harm both your personal health and my client's business, putting a screw in your sandwich would accomplish both of these goals, wouldn't it?
I'm sure that it would. However, since these protesters were protesting on the belief that they are against cruelty of all kind against animals and humans, I find it very hard to believe that any of them would intentionally harm a human being like that, since they're unwilling to even eat a chicken per se, which is not capable of high rational thought.
Well, you testified earlier that swallowing a screw that day was harmful to your health, correct?
Yes, it was very harmful to my health.
And you've already told us that serving a customer food containing a foreign object was bad for your restaurant's business, right?
It likely would be, yes.
So putting a screw in your chicken sandwich harmed both your personal health and my client's restaurant, right?
Yes, it did certainly harm my health. I have no idea whether or not it has harmed Mr. Jennings' restaurant.
I have no further questions at this time, Your
Honor. Redirect, Your Honor.
Yes, you may.
All right, Miss Saylor. Who do you believe, or actually, rather, Miss Saylor, take us through your visit to Eat More Chicken and everything that happened there.
Well, after I got to the front of the line, Mr. Jennings came out and took my order personally and assured me that he would make sure I got the freshest, hottest sandwich available. And then after quite a while for a fast food restaurant, frankly, he brought me my sandwich himself, at which point I tried to eat it and swallowed the screw.
Right. And finally, Miss Saylor, will you please go through your entire relationship, every single interaction you've had with the protester that was arrested at your restaurant?
Yes, well, quite a few years ago, back when he would have been just a teenager, I think, that group was protesting at my restaurant. And I did receive complaints about one in particular. Most of them were very peaceful, and one of them was peaceful but rude. So I did call the police to have that protester in particular escorted away. We have not had any interaction since then. I see the protesters around town, but they've never caused me any trouble.
All right. Thank you, Ms. Saylor. No further questions, Your Honor.
Any time left for recross?
I have no recross, Your Honor.
All right.
The plaintiff rests, Your Honor.
All right. Thank you. I believe we're ready for the proof of the defense now.
Yes, Your Honor. The defense call Mr. Drew Jennings to the witness stand. Would you please state your name for the court and the jury and spell your last name for the record?
I'm Drew Jennings. It's spelled Jenings.
And today the jury has heard testimony that you're the owner of the Eat More Chicken restaurant. Is that accurate?
Yes, it is. My wife and I, we opened it across town, June of 2019.
And have you been in trial throughout today's proceeding?
Yes, sir, I have.
So have you heard the plaintiff's accusations that you intentionally placed a screw in Bryson Saylor's chicken sandwich?
I know that's what she's claiming, yes.
So I have to ask you, did you place a screw in Miss Saylor's chicken sandwich on September 5th?
No, I did not. I mean, it's completely untrue. I would never try to hurt anyone like that. Look, and believe me, I feel awful about what happened to Miss Saylor, but I didn't do anything to hurt her.
Did you have any reason to believe that Bryson Saylor's sandwich may have been contaminated when you gave it to her on the day in question?
No, I mean, it doesn't make any sense. Why would I serve a customer a sandwich with a screw in it? I mean, that would be like sabotaging my own business. Why would I do that? I didn't open a restaurant to hurt people.
Did you have any reason to be at all angry with Miss Saylor on September 5th?
To be angry with her? I mean, no, not at all. I barely even knew Miss Saylor. Well, I've seen her on TV, and the commercials that she has, but I mean, that's it.
Had the two of you ever even met before?
No, never.
Well, you mentioned just a few moments ago that putting a screw in your own restaurant's food would be like self-sabotage. Can you explain what you mean by that statement?
Look, I mean, we've been open, 3 months? I mean, not even that, really. It's a big investment, and we're competing for customers. And we're working like heck to build up our reputation, become a part of this community. So putting a screw in a customer sandwich on purpose, I mean, that's just a recipe for financial disaster.
Is it true that you were the person who took Bryson Saylor's chicken sandwich order when she came into your restaurant?
Yes, it is. I mean, I saw her come in, and I wasn't really sure why she'd be there. And of course, I didn't really want her doing something like trying to get our customers to go to her restaurant. So I decided I'd wait on her.
And were you also the person who checked her order?
Yes, I was.
The jury has heard testimony today that you personally delivered the order. Is that true?
It is, yes.
Well, given that you personally delivered the order and you took the order, was the sandwich ever outside of your control?
Well, I left it alone just before I served it. You see, as I was bringing the food to Miss Saylor's table, I mean, it was on a tray, right? And, well, I realized that we'd forgotten the napkins, so I set the tray down on an empty table, and I went back to the counter to get some.
When you returned, did you notice anything out of the ordinary in regards to the sandwich?
Yes, actually. Well, the bun on top of the sandwich had been moved. I mean, it was off to the side instead of being square on top like it had been when I set the tray down. I mean, at the time, of course, I didn't think much of it. But, looking back, it seems pretty important.
Well, regarding who might have had the opportunity to tamper with the sandwich, was there anyone in the immediate vicinity of that table when you returned?
Well, yes, actually. I mean, that day my restaurant was being targeted by this massive group of protesters. I mean, they were all over the place. waving signs and yelling. But one of the chicken protesters, and it was this guy or this girl actually, in a full chicken costume. She was standing right next to the empty table where I set Miss Saylor's food down.
Objection, Your Honor. The witness is testifying from what is the case summary. This is not in the witness's affidavit, and under Rule 3, witnesses are bound by their affidavits. Additionally, this would go to the lack of personal knowledge this witness has. And additionally, the case summary is hearsay and has not been entered into evidence.
A response, Your Honor?
Go ahead.
Your Honor, we haven't entered the case summary into evidence. Furthermore, this is in the witness's affidavit.
All right. Objection overruled. You may proceed.
Now, you mentioned this group of protesters. Are you aware what this group of protesters is protesting against?
I mean, they're animal rights activists, so basically they object to any businesses that sell chicken, like us and like Sailorman's. I mean, they try to disrupt our businesses any way they can. I mean, like Mrs. Saylor said earlier, it got so bad for her that she had to have one of them arrested. I mean, frankly, if one of them had the opportunity to put a screw in Miss Saylor's sandwich and then have me and my business take the blame for it, well, there you go.
You mentioned that the protesters try to disrupt your business. Was your business at all disrupted by these protests?
Yes, very much so. Our sales were off the proverbial cliff, and I wasn't really sure if we were going to make it. I mean, this whole thing's been all over the media, and believe me, it's not true when they say that any publicity is good publicity. I mean, who's going to eat at a restaurant that everybody thinks puts screws in their food? That's why I said earlier, it makes no sense to say I would do this to my own restaurant. Ruin my dream.
Well, returning to the protester wearing the full chicken costume, did you see that protester at any other point that day?
Well, yes, I saw her in line actually, right behind Miss Saylor when she ordered. And then, I mean, next time I saw her, she was right next to those tables where I set Miss Saylor's food down.
And after you returned with the napkins, what did you do?
I mean, I went to pick up the tray. I took it to Miss Saylor, and I gave it to her. And next thing you know, she's yelling that there's something wrong with the sandwich and that she swallowed a nail and all that.
What did you do at that point?
I didn't know what to think, but of course I was concerned for her. So I offered to drive her to the hospital. But I mean, she refused any help and she left. I guess she drove herself to the hospital.
Is there anything else you'd like to tell this jury today?
I just want to say that I didn't do this. I would never try to hurt any one of my customers.
I have no further questions at this time, Your Honor.
You may cross-examine.
Thank you, Your Honor. Mr. Jennings, can you hear and see me well?
I can, yes.
Thank you. So your Twitter handle is @#1chickenfan, correct?
It is, yes. That's my advertising Twitter.
So you use this account to advertise, don't you?
Right, for Eat More Chicken.
All right, thank you, Mr. Jennings. Your Honor, may co-counsel screen share what has already been entered into evidence as Exhibit D?
Yes.
Thank you, Your Honor. Mr. Jennings, these messages were sent from @No1ChickenFan, correct?
Yes, the gray ones, yeah.
And you do have access to this account, don't you?
Well, I do. Yes, it's for advertising, like I said.
So I would like to direct your attention to the last two messages. So you sent, "I think you're just jealous there's a #new Chicken King in town," didn't you?
I did, yes. I put the little hashtag in there. I thought it was funny.
You also sent the message that says, "Going to enjoy watching your chicken kingdom crumble," didn't you?
Yes, yeah, I mean, everybody's calling that the Chicken Kingdom. It's kind of a fun little play on words.
Thank you, co-counsel. Let the record reflect that co-counsel has stopped screen sharing.
So ordered.
Mr. Jennings, when you realized Miss Saylor came into your restaurant, You wanted to personally serve her, correct?
I did, yes. I wanted to make sure that she didn't make a scene or anything like that.
So you got rid of the cashier, Miss Andrews, so you could serve Miss Saylor. Isn't that right?
Well, I asked her to, take a break so that I could, deal with the problem front hand.
And you even took a toolbox with you to the register at this time, didn't you?
No, I left it where I was using it.
And Mr. Jennings, you were here and present for the testimonies earlier, correct?
Yes, I have been.
And you were there when Miss Andrews testified that they saw you at the register with the toolbox, right?
Well, I was there, yes, and she was looking pretty tired that day, but I guess she mixed it up.
And you never mentioned in your affidavit where you left the toolbox, did you?
No, I left it right where I was using it. I dropped everything and I went straight to the counter.
Your Honor, may I screen share what is the witness's affidavit for impeachment purposes?
Yes, you may.
Thank you, Your Honor. Just give me 1 second. All right, Mr. Jennings, let me just find it real quick. All right, please read along as I read out loud. In my rush to get to the register, I did not have time to put the toolbox, which contained the tools I had been using to fix the picture, back in my office. So, Mr. Jennings, let me re-ask my question. You did not leave your toolbox with you when you were done, did you?
I didn't take it to the counter. That's not at all what that said.
You didn't leave it where you did when you were done using it, did you? Like you just testified a few moments ago.
Well, I said I dropped everything like we just read, and I didn't take it to the counter.
All right, Mr. Jennings. And you are aware that during discovery, the same screws that were found to stipulated from Miss Saylor's stomach were found in your toolbox, correct?
You're right. A couple months later, I think they were the same screws. You're right.
And after taking Miss Saylor's order, you then decided to serve Miss Saylor's sandwich. But before doing so, you abandoned the sandwich in an unattended table. Isn't that right?
Well, I left it at an empty table just to grab the napkins.
And so you went to get napkins. So you went back to the register, correct?
Oh, you're right.
And after you got your napkins, you went back to the unattended table, didn't you?
I did, yes, just to get everything ready for Bryson.
And when you did this, you noticed that the sandwich bun was tilted. Isn't that correct?
It was actually. It was slightly off the sandwich, like you said.
So you touched it to fix it, didn't you?
I did. I nudged it back in place because, at the time, I didn't think anything of it,
So you saw that the sandwich bun was tilted, but you still decided to serve the sandwich to Miss Saylor, didn't you?
Well, yes, I just put it down there, and I assumed that it had just fallen off to the side. I really should have thought about it more.
So in this moment, you thought it was safe to serve a sandwich that could have been contaminated?
Well, sure. At the time, I didn't think that anybody would have messed with it.
And moments after you personally served Miss Saylor her sandwich, you heard a loud commotion coming from her, didn't you?
I did, yes. It was crazy. They're yelling about a nail and, I don't know, about eat more chicken. It was crazy.
So on September 5th, 2019, your business competitor and customer was screaming in pain, correct?
Yes, she was. And of course, I was concerned for her right away.
So you say you were concerned and you offered help, yet you never checked up on Miss Saylor, a customer and your competitor, did you?
Well, right after she was yelling for help, of course, I offered to drive her to the hospital.
But you never called later on.
No, I didn't know her phone number. And I don't know. I just assumed that she wouldn't want to talk to me anymore.
And you didn't visit her in the hospital either, did you?
No, I didn't know where she went. And I don't know. You ever get the feeling that somebody hates you?
So, Mr. Jennings, on direct examination, opposing counsel asked you some questions about the protesters. You mentioned that you asked the protesters to leave that day. Isn't that correct?
I did, yes. I told them that they weren't welcome to my restaurant.
But you didn't feel the need to tell the protesters to leave earlier that day, did you?
Well, no, I mean, I'm not going to, take away their rights or anything. I mean, they're able to. It got out of hand at that point.
And you are not able to identify any specific protester today, are you?
No, I'm not really clear on any other names.
And you never saw the plaintiff, Miss Saylor, with the screw, did you?
With a screw? Of course not, no.
And you neither saw a protester with one either, did you?
No, I didn't really see any screws that day, to be honest.
So you saw no one with the screw, correct?
No, nobody showed me a screw. Of course, it's probably a safety hazard.
And you neither saw the plaintiff, Miss Saylor, or the protester place a screw in the sandwich, did you?
No, I would, of course, take the sandwich back and make sure that everything was okay for Bryson if I saw that.
Thank you, Mr. Jennings. No further questions at this time, Your Honor.
Redirect.
I have no redirect examination, Your Honor.
Thank you. You may call your next witness.
The defense calls Mr. Ryan French. Before we begin, Mr. French, can you see and hear me okay?
Yes, but I am not so familiar with the Zoom. Can you hear me?
I can hear you fine, Mr. French. Thank you. Please state your name.
My name is French, Ryan French.
And where are you from?
Originally, you ask, I am from Tarragona, near Barcelona, in Spain. So it is that I am Spanish, but my name is French. One of life's little oddities, I suppose. I guess you can blame mi padre, my father, for that.
And where do you live now?
Today, I live here in Tennessee. You see, I was retired in Spain and a widower. But then I met Ellie on a cruise, actually. She's my wife now. Ellie is from here. So we met, we married, and I moved here to be with her.
Are you still retired, Mr. French?
Oh, no, I work for Mr. Jennings now at his restaurant. Eat More Chicken, it's called. I am the manager of the store, you see. When I first moved here, I needed something to do. And it was Ellie who told me that Mr. Jennings was going to open a restaurant. I thought about being how do they say? A greeter at the Walmart. But I prefer a job where I can use my hands. That is while they still work.
Were you present at the Eat More Chicken restaurant on the afternoon of September 5th, 2019, when Mr. Saylor, or rather Mrs. Saylor, claims that she was given a chicken sandwich with a screw in it?
Yes, of course. As I say, I am the manager of the store. So I was there all that day long.
Mr. French, we heard testimony about a group of protesters present at the Eat More Chicken restaurant on September 5th. Did you see these protesters?
I did see them, yes. I thought it was a very strange thing. Very strange, I thought. Right outside our door, there are all these people in a protest, and they had these signs they were waving. Right outside our door they were. And I thought to myself, Dios mío, all these people in front of our door, how is it the customers are supposed to get in? So as the manager, I went to them and I said to them that they should move a little from our door so the customers can get in. And it's not good for business if the customers can't get in, you know?
Do you remember seeing a protester in a full chicken costume?
Yes, I do remember that. Head to toe, this person was dressed as if he was a chicken. Again, quite the scene. I was outside trying to get all the people away from our door. And there she was, walking right in the door.
Can you tell us, Mr. French, as of this date, September 5th, 2019, did you know who Bryson Saylor was?
Yes, I knew what she looked like. You see, Mrs. Saylor was on the TV many times with commercials for her restaurant, Sailor Man's it is. So I had seen her on the TV.
And because you'd seen her on television in commercials, would you have been able to recognize her as of September 5th?
Yes, I knew what she looked like.
So when you saw that protester in the parking lot, had you seen Bryson Saylor inside the restaurant?
Mrs. Saylor? No, not at the point when I saw the protester go inside. But just later, yes, I did.
So when the person in the full chicken costume, the protester, went inside, what did you do?
It was then that I went back inside.
Did you see Bryson Saylor at that point?
Yes, I did. I did see her then, yes. She was, Mrs. Saylor is what I mean. She was there in the order line. And behind her was the one dressed like a chicken.
As the protester in the full chicken costume went inside, did you hear that protester say anything?
You mean to ask, did the chicken talk? See, yes, she did.
Please tell the jury what you heard.
Well, it was, how do you say, bizarre. It was as the person in the suit was going into the restaurant. And just then, I heard her say, fate has given me...
Your Honor, under Rule 802 hearsay and 403, which, my apologies. One second, Your Honor. Exclusion of relevant evidence on grounds of prejudice. I object to this hearsay statement. One, it is hearsay under 802. Additionally, under 403, because we don't actually know the context of this statement and who the declarant was, this is unfairly prejudicial to the jury, as they won't be able to understand the full context of the statement and will have to take it at face value outside of context, and it will be misleading to them.
A response, Your Honor?
Yes.
First, to the 802 hearsay objection. Hearsay requires the truth value be asserted in the statement itself. Here I proffer that Mr. French is going to testify that the protester said, fate has given me an opportunity I can't pass up. Obviously, fate had given the protester no actual opportunity in this case, but rather the statement showcases the motive behind the statement. That because the protester believed that there was an opportunity, she was willing to go inside the restaurant and act upon that opportunity. But regardless of its truth value, Your Honor, this statement is still admissible under hearsay exception 8033, which allows for the declarant's intent, plan, and motive to be asserted in the statement. And as to the 403 objection, Your Honor, all of those motive questions and those intent questions make the statement highly probative. And remember that under 403, there has to be a substantial outweighing of the prejudicial value for the probative value to be inadmissible.
All right. As to the hearsay objection, I believe that it is the state of mind under 8033, and it is an exception to the hearsay rule. That one's not a close call. The 403 objection is a very close call. That's really close. But I believe I'm going to go ahead and allow the testimony. I don't think that the probative value is substantially outweighed by unfair prejudice. You may proceed.
Yes, Your Honor. Mr. French, would you like to tell us what the protester said?
Yes, as I say, it was as they were walking into the restaurant. Then just then, I heard her say, fate has given me an opportunity I can't pass up. And then she walks right in. What she meant by this, I do not know. But this is what she said.
So what happened after you heard the protester say fate has given me an opportunity I can't pass up?
As I say, Mrs. Saylor was in the order line. And I thought Mr. Jennings needed to know this. So I went and I told Mr. Jennings that she was there.
Where was Mr. Jennings when you told him about Mrs. Saylor?
He was in the back, near the toilets. He had a hammer and he was hanging up a sign. Or perhaps he was fixing it. I do not know, but that is where he was.
Let me ask you this, Mr. French. Did Mr. Jennings have any screws in his possession when he told him Mrs. Saylor was there?
Did Mr. Jennings have a screw? No, he had a hammer, not a screwdriver.
What happened after Mrs. Saylor ordered her food?
We were so busy, I had to get back to my job. So I went to go wipe the tables because we needed to have them ready for our customers. And it was then when I heard Mrs. Saylor begin to cry out that she had swallowed a nail.
Did you try to help Mrs. Saylor?
But of course I did. It seemed to me that she was in some kind of distress. I came over and I got out my cell phone. I asked her if she wanted me to call 911, but she said no. She did not want that.
How did Mr. Jennings react?
Just as you would expect. He came over at once, and he also offered to help. He said to...
Your Honor, again, 802, this is hearsay as it is an out-of-court statement.
Response?
Your Honor, this still goes to the motive of the declarant. And regardless, it's not being asserted for its truth value, but rather the intention of Mr. Jennings to want to help Mr. Saylor or Mrs. Saylor.
Your Honor.
Yes, ma'am.
Let me respond. As my opposing counsel has stated, they are attempting to assert that the defendant was someone who would want to help, and that is directly what is contained in their statement. Therefore, it does go to the truth of the matter asserted as per Rule 802 hearsay.
All right. I'm going to go ahead and allow it and deny the objection. Go ahead.
So what did Mr. Jennings do, Mr. French?
As I say, he offered to help, and he said to Mrs. Saylor that he would take her to the hospital.
And did the plaintiff accept Mr. Jennings' offer to drive him to the hospital?
Mrs. Saylor? No. She just stood up and walked right out the door.
Thank you, Mr. French. No further questions at this time, Your Honor.
Ms. Cantor, you may cross-examine.
Thank you, Your Honor. Now, on your direct examination, Mr. French, you stated that there was a protester in a chicken costume. However, there were many protesters at Eat More Chicken that day in chicken costumes. Isn't that right?
Yes, I don't know the exact number. Maybe 20 or so. I'm not too sure.
Right. And so, Mr. Jennings, as soon as you saw Miss Saylor in the restaurant, you rushed to tell the defendant, didn't you?
Mr. Jennings, I am honored, but I did go to tell him, yes.
Right, and you noticed that he had a hammer with him, didn't you?
He did, yes. As I say, he could have been fixing the signs or hanging them up. It was because of our autumn and the new spice latte that we had coming in.
Right, and as soon as you told the defendant about Miss Saylor's arrival, he said that he was going to be the one to serve Miss Saylor. Isn't that right?
No, he said to not let anyone else serve Mrs. Saylor. And I understand him too. I know I make a good sandwich, but Mr. Jennings, he is the owner. He makes the best sandwich we have.
That's right. The defendant said that he didn't want anyone else serving Miss Saylor. However, he also said that he was going to be the one to personally serve Miss Saylor. Isn't that right?
Exactly. It's what I say. He makes the best sandwich that we have. I know I'm the manager, but he's the owner.
And so the defendant wanted to use his personal recipe for the sandwich he was going to serve to Miss Saylor.
I'm a bit confused about which recipe you are referring to. I was not aware of any recipe.
Mr. Friend, the defendant told you that he was going to serve Miss Saylor, right?
Yes,
He answered, Your Honor.
Overruled. You may go ahead.
I'll repeat my question. Mr. French, the defendant told you that he was going to serve Miss Saylor, right?
Yes, he did.
And as you just said, the defendant makes the best sandwiches, doesn't he?
Well, yes, he's the owner. He's had the most experience.
Right. So the defendant wanted to use his personal recipe for Miss Saylor, didn't he?
Once again, I'm a bit confused about which recipe. No, the customer orders at the counter and we make the sandwich just like they order it. There's no recipe. If you want pickles, we give you pickles. If lettuce, you get lettuce.
Mr. Frank, let's pivot to the weeks before September 5th. Now, the defendant didn't tell you that they owned the #1 Chicken Fan 1 account, did they?
I object to relevance, Your Honor.
Your Honor, if I may respond.
You may.
Your Honor, this line of questioning goes to show how the defendant had intent before September 5th to sabotage Miss Saylor's business by showing how this was a planned and motivated thing quite prior to the incident. And I'm doing that by establishing that the defendant kept his online actions a secret, even though he claims that that account was used for business. He did not even tell his manager, and his manager knew nothing about it.
All right. I believe the testimony will be relevant. You may proceed. Overruled.
I'll repeat my question. Mr. French, you heard today from the defendant himself that he is #1 chicken fan. However, you didn't know that prior to today, did you?
No, I was a bit confused. I do not know what the #1 chicken fan is. What is it?
Right, Mr. French. You knew nothing about his online account. Even though you were the manager at Eat More Chicken, the defendant told you nothing about this, did he?
No, believe me, I'm not the one to go to about online stuff.
Right, so you knew nothing about it. Let's focus back in on September 5th, right after the defendant told you that he was going to be the one to serve Miss Saylor. You went to go wash tables, didn't you?
Yes, as I say, we were very busy, and we did not have enough before I started wiping.
Right, and so as a manager, you were doing grunt work while the defendant was preparing Miss Saylor's sandwich, isn't that right?
Well, yes, the manager is more of a day-to-day position, so I often clean the tables.
And so while you were cleaning these tables, you didn't see the defendant prepare Miss Saylor's sandwich.
No, I was pretty busy with the tables.
Right, and so you also didn't see the delivery of that sandwich to Miss Saylor.
The delivery? No. It was in the restaurant.
Mr. French, other than semantics, you did not see the defendant give the sandwich to Miss Saylor, did you?
The semantics?
Mr. French, please answer my question.
I was just a bit confused.
Your Honor, can you please instruct Mr. French to give my questions an answer?
Mr. French, go ahead and answer the question if you understand it. You may repeat it if you need to.
I'll go ahead and repeat it. Mr. French, you did not see the defendant deliver the sandwich to Miss Saylor, did you?
Oh, no. I was cleaning the tables. I did not.
Right. Thank you, Mr. French. No further questions, Your Honor.
Any redirect?
No redirects, Your Honor.
All right, thank you. You may call your next witness.
The defense calls Taylor Tarr. Mr. Tarr, before we begin, can you see and hear me okay?
Yeah, you look nice, yeah.
Please introduce yourself to the jury and spell your last name.
All right, I'm Taylor Tarr. That's T-A-R-R.
What do you do for a living?
I'm an accountant, professional bean counter, as they say.
Tell the jury a little bit about yourself. Where are you from?
My mom was a sixth-generation Tennessean here. So I was born here too. But my pops was from Brooklyn, so we moved back there when I was, when I was a toddler. So I grew up in the city.
When do you move back to Tennessee?
Oh, geez, don't get me started. Summer before my senior year, for crying out loud. I mean, what a time to move a guy, huh? Anyways, I graduated high school here. Even got voted most congenial, if you can imagine that. I mean, that's gotta be a first for a New Yorker, you know what I'm saying?
Did you go to college after you graduated?
Sure. I stayed in Nashville and studied accounting.
Did you get your degree in accounting?
Oh yeah, I got my bachelor's. Paid my way through school gigging over at the Zany's Comedy Club. I was having so much fun here, I stuck around and got my master's while I was at it.
And Mr. Tarr, where are you currently employed as a professional accountant?
Oh, well, I opened my own accounting firm, actually. I'm a small business owner these days. It sort of gives me the freedom to make my own schedule, you know?
And Mr. Tarr, I'd like to turn your attention to why you've been called to the virtual courtroom today. Do you know a woman named Bryson Saylor?
Oh, yeah, I know Mrs. Sailors. She's good people.
How do you know Miss Saylor?
Well, she's a friend of mine and also a client. I run the numbers for a restaurant, Salemans.
Mr. Tarr, are you aware that Miss Saylor has sued a competitor, claiming that the competitor fed her a metal screw?
Yeah, I heard about that. It's why I'm here, right? She sued the owner of the Eat More Chicken place. Not surprising.
Why do you say that's not surprising?
The numbers, I saw what happened to Salemans financials after the new place.
Your
What
Honor,
is-
may I make my objection?
I'm sorry, go ahead.
Thank you, Your Honor. I object to this under Rule 602, lack of personal knowledge. Ms. Tarr does not have personal knowledge as to the contents of why Ms. Saylor filed this case, nor does he testify to it in his affidavit. So therefore, he cannot testify on this matter today, as he does not have personal knowledge as to why Ms. Saylor would have done this, and he's speculating as to why Ms. Saylor would have filed this lawsuit. Therefore, it's inadmissible.
Response?
Yes, Your Honor. I'm not asking Mr. Tarr to speculate as to anyone's motive. I'm rather asking him to delve into the financial statements of Ms. Saylor, which he has personal knowledge of as her accountant.
All right. You may proceed. Overrule. Go ahead.
Mr. Tarr, would you like me to repeat that question for you?
Yeah, I missed it.
Why do you say that it's not surprising that Miss Saylor sued Eat More Chicken's owner?
Oh, yeah, that's what I was saying. I run the numbers, so, all the number stuff. Salemans took a big hit when that new place came to town.
Could you be more specific?
Yeah, well, it's like this. I've been doing the numbers for Salemans for years. Bryson and I, we just go way back. I love her like she's my own blood. But, when the new place opened up, Salemans took a huge hit financially.
Can you quantify for the jury just how much Sailorman's sales had dropped?
Sure, I mean, Salemans sales were down to the tune of 25%.
What did you think when you saw that?
I was just thinking, for the love of Mike, why me, right? I mean, 25% is not a small deal, and now I was the one that was going to have to, break the news to her.
Did you break the news to her?
Yeah, of course, I always communicate with all my clients. Good or bad stuff, I have a sort of ethical obligation to make sure, well, everyone knows what's going on. Mrs. Saylor's no different.
Did you speak with Miss Saylor over the phone or in person?
We met in person, when you gotta break bad news, I do that kind of thing face to face. It's better for everyone that way.
And how did Miss Saylor react to hearing her sales had decreased 25% after Eat More Chicken opened?
Yeah, it wasn't good, She started screaming and yelling and all that, and then she just kind of stormed out of the place.
Can you tell the jury what she said while she was screaming?
Yeah, it's like this. I wanted to give her some space.
Wait a minute, stop. There's an objection. Go ahead.
So
Your
sorry.
Honor, what this witness is about to testify to is a potentially misheard statement, which is thus inadmissible under Rule 403, as it has a substantial danger of having unfair prejudicial value that outweighs the probative value. Mr. Tarr will testify that he overheard these statements on the phone while he was in another room, so it's substantially likely that he could be misleading the jury because he would be taking these statements out of context, and they may be unfairly prejudicial to my client in this light.
Well, I think this is when we'd send the jury out and have a jury out hearing on this. But I don't believe it's hearsay, and even if it is, it's 8033 existing state of mind as to whether or not he misheard. I haven't heard enough proof about that. I don't think to really make a decision on it. I'll hear from counsel.
Your Honor, may I explain why it would be unfairly prejudicial?
Sure.
I would inquire into on cross-examination how, when Mr. Tarr overheard these statements, he first of all only heard one side of the conversation, So he wasn't able to hear the context for that conversation or what they were talking about, and therefore he has no confirmed idea of what they were talking about. Additionally, he had stepped out of the room to make copies, so he was, for the most part of it, not in the same room as Miss Saylor, and he additionally only came in the middle of the conversation, so he wasn't able to catch that first part. For all of these reasons, there is a substantial danger that the prejudicial value of this evidence would greatly outweigh any probative value that it may offer.
May I respond? Yes, Your Honor. This definitely goes to the weight, not the admissibility of the testimony. Ms. Thacker's free to inquire onto this on cross-examination, but as of now, these statements were heard by Mr. Tarr, and as you said, they're not hearsay, so the jury does have a right to hear what Mr. Tarr perceived and heard.
All right. Again, I think this is a close call, but unlike 404B, 403 uses the word substantially. So probative value substantially outweighed by unfair prejudice. So I'm going to overrule the objection. Respectfully, you may proceed.
Mr. Tarr, can you tell the jury again, what did Ms. Saylor say?
Yeah, it's like I was saying. I left the office and I comes back and she says, no one comes after my business.
Did she say anything else?
Yeah, actually, she said she was going to put a stop to something.
What did you think when you heard that?
To be honest, I didn't know what to think. Now that I found out about this lawsuit and stuff, it makes more sense.
Mr. Tarr, did you tell the defendant about Ms. Saylor about the decrease in sales before this lawsuit was filed?
Before this lawsuit was filed, I don't really know when this whole thing started up.
My apologies, Mr. Tarr. Did you tell Ms. Saylor about her decrease in sales before October 31st, 2019?
Yeah. It was before October because it was in September when I broke the news. So yeah, before October 31st and before this lawsuit, if that's when it got filed. Like I was saying, it makes a lot more sense now.
Thank you. Nothing further.
Redirect.
May I proceed with my cross-examination first, Your Honor?
I'm sorry. Go ahead.
Thank you, Your Honor. Hello, Mr. Tarr. My name is Lauren Thacker, and I'll be asking you a few questions today. Before I proceed, can you see and hear me well?
Yeah, everything looks good.
Mr. Tarr, you testified on direct examination that Mr. Saylor's sales were down, and that Ms. Saylor's sales were down in her response to this. But in your opinion, people are typically mad when dealing with money, isn't that right?
I mean, yeah, I guess, when your life's money, you get a lot, you're happy. When you get a little, maybe not so happy.
And Mr. Tarr, you were present for the testimony of Miss Saylor, weren't you?
Yeah, I think so, yeah.
So you heard Miss Saylor testify under direct examination that she was not worried about her financial declines in the long run, correct?
Yeah, I'm sorry. The guys who told me to come here, they was just saying answer questions. They didn't say anything about listening. I'm like up to my eyeballs in tax returns. It's tax season. I had stuff to do. I'm sorry.
Objection, Your Honor. I would like to say that you agreed in our preliminary matters, we as the plaintiff addressed that witnesses are not to be sequestered under Rule 16. So I would ask that you instruct this witness to answer based on what he has been present for in court today and that he does have knowledge of and he should have been listening to.
May I respond?
Sure.
Your Honor, Rule 16 does provide for the lack of sequestration of witnesses. Mr. Tarr said he was present in the Zoom courtroom, but he was obviously doing tax work as an accountant and not listening closely to what Ms. Saylor said. Therefore, there's no obligation under the rules to listen in closely to everything any other witness says.
I think we're far afield here I'm used to getting all these objections outside the scope of the mock trial universe. So I'm going to allow this line of questioning. Go ahead.
Thank you, Your Honor. So, Mr. Tarr, you were present when Miss Bryson Saylor said that she was not worried about her financial success in the long run, correct?
Yeah, I guess so, yeah.
And so you were here when she said that this is regular, that when a new business opens and a new restaurant opens, that something like this would happen, correct?
I mean, if you say so, yeah, I don't really know too much.
And Mr. Tarr, you testified under direct examination about a phone conversation that you overheard, but you had no idea who Miss Saylor was on the phone with, did you?
Nah, I mean, it's like I was saying. I came back and I heard her screaming. I don't really know what she was screaming at.
So you had only heard one side of the conversation, didn't you?
Uh, I guess so. You know, I heard her screaming, yeah.
And you came in the middle of the conversation?
Well, it's like I was saying. I went down and I came back up and I had her talking about a business or whatever.
And Mr. Tar, you weren't even in the same room as Miss Taylor for the majority of that phone conversation, were you?
Yeah, I was like right outside the door when I heard her.
Thank you, Mr. Tar. Additionally, you were not at Eat More Chicken on September 5th, 2019, were you?
Same day. Nah, I wasn't there. Nah.
So you didn't see any protesters or screws that day, did you?
Oh no. I wasn't there.
Thank you, Mr. Tar. No further questions, Your Honor.
Anything further?
No, Your Honor, the defense rests.
All right. Suppose we've come to the part of the trial when we will hear the closing arguments.
Yes, Your Honor. Would you like me to go ahead and move into those?
Yes, please.
All right. First, I would like to reserve up to 1 minute of my closing for rebuttal.
You may have that.
All right. Motive means an opportunity, the perfect recipe for sabotage. May it please the court, Your Honor, Mr. Klimico, members of the jury. At the beginning of this trial, my co-counsel Lauren Thacker made a promise to you. That promise was to show you by preponderance of the evidence, a mere tip of the scale, that the defendant more likely than not committed battery by intentionally, harmfully, and unlawfully placing a screw in Miss Saylor's chicken sandwich. We only need to look at the defendant's special ingredient, a 1-inch galvanized screw, to know that Miss Saylor has proven her case and done far more than merely tip the scale in her favor. Today, you've heard an all too common story. A big franchise coming into a small town and running local shops out of business. However, Miss Saylor's little business was too strong. The defendant was scared of my client's success and reputation in poultry. He discovered that his budding business would never be able to win over my client's loyal customers. This threw the defendant into a tizzy. He had invested everything to start his own business, but Sailorman's, his competition, just wasn't dying fast enough. The defendant's motive? Destroy all competition, no matter how small. The defendant's motive can be seen through his actions. First, the defendant circulated outrageous claims online about Miss Saylor's small business utilizing inhumane practices. You saw their Twitter conversation. The defendant wanted to see my client's business be destroyed. The defendant couldn't beat Miss Saylor legitimately, so he had to fight dirty. While Sailorman's did experience a loss in sales, Miss Saylor wasn't worried. She knew her loyal customers would come back just as they always had. However, the loss in sales wasn't enough for the defendant. So next, he attacked Miss Saylor by committing battery. He knew that his online slander would eventually get Miss Saylor into his business, giving him the opportunity to strike. The evidence shows that the defendant served Miss Saylor while in possession of a toolbox that was later found to contain screws exactly like the one extracted from Miss Saylor, as Dr. Kerr showed us. The defendant had means to slip that screw into Miss Saylor's food because he intentionally took control over Miss Saylor's order. He told the manager, Ryan French, to not let anyone else serve Miss Saylor. Next, the defendant approached Avery Andrews, who was manning the register, and pushed her out of the way to serve Miss Saylor himself. The defendant made sure that no one else in the restaurant would see him slip that screw into the sandwich. During the busiest time of the day, the defendant had the manager wiping down tables and forced the cashier to go on break. The defendant had motive: destroy Miss Saylor's business. Means: a screw and no one to watch him place it. Opportunity: Miss Saylor in his restaurant innocently ordering her lunch. The defendant had the perfect recipe for sabotage and didn't hesitate to use it. The defendant's special ingredient, a 1-inch galvanized screw, sent Miss Saylor to the hospital. That's why we're here today, to get justice. My client wants to ensure that no one else will suffer at the defendant's hands. Today, the defendant tried to cast doubt by blaming a protester that no one can even name. But ultimately, no one else had the motive, means, and opportunity to strike at Miss Saylor like he did. In his opening statement, Mr. Bellardo said that someone else did have those three things, though. But where was the evidence for that? Laid bare, the real evidence fully condemns the defendant for his vicious attempt to annihilate his competition. We ask that you return the only verdict that is supported by the evidence and find the defendant liable for battery and award Miss Saylor damages. Thank you.
Defense closing argument?
Yes, Your Honor. May it please the court, Ms. Cantrell, members of the jury. As I listened to Ms. Cantrell's argument just now, one question kept repeating itself over and over in my head. Why? Why in the world would Drew Jennings sabotage his own business? Why would he throw away his dream and willingly choose the negative publicity and the loss of sales that would inevitably result from attacking his own customer? Members of the jury, when you sat down and logged onto your computer to join the proceeding, you didn't leave your common sense in the other room. You brought it right here to this trial. And when you apply common sense to the facts you've heard today, the logical explanation is not that Drew Jennings sabotaged his own new restaurant. No. Logical explanation for how a screw got on that chicken sandwich is that a radical protester saw an opportunity to kill two birds with one screw. And she took it. But before I talk about the evidence that points at the protester in the full chicken costume as the real culprit, let's talk about the burden of proof. Because it was not Mr. Jennings' burden to prove anything today. It was the plaintiff. And the plaintiff alone who had to prove by preponderance of evidence that Drew Jennings caused harmful and offensive physical contact with Bryson Saylor by intentionally placing a screw in Mr. Saylor's food. Now, if you consider all the possibilities about how a screw could have ended up on that sandwich, the plaintiff's story of self-sabotage, the story that it is their burden to prove, is the one possibility that completely defies logic. None of the plaintiff's witnesses offered any actual proof about who put the screw on the sandwich. The best they could offer was that the plaintiff and Drew Jennings are competitors. Drew Jennings took the plaintiff's order and delivered the food, and that Drew Jennings had a toolbox somewhere inside the restaurant. Members of the jury, that's all true. It just doesn't prove anything. Mr. Jennings told you he never even took that toolbox to the counter. And let's remember that on cross-examination, Miss Saylor even admitted that my client was nothing but polite and friendly on September 5th. No anger, no threats, no menacing behavior, just polite and friendly. And polite and friendly doesn't prove intentional battery, it proves great customer service. That's probably why Mr. Jennings was winning in the free market to begin with. It was the plaintiff's business. I was down 25%. Mr. Jennings stood to gain nothing and to lose everything if he attacked his own customer. The plaintiff, on the other hand, filed this here lawsuit after he learned that she was losing business to Mr. Jennings. Ms. Cantrell also agrees that when Mr. Jennings left the sandwich at an empty table, it was tampered with. The bun was askew. So instead of emphasizing how Mr. Jennings carefully fixed that bun, let's ask how that bun was unfixed in the first place. Who unfixed that bun? Who tainted that chicken recipe with a screw? Who had the motive, the means, and the opportunity to kill two birds with one screw? The chicken protesters. The same group that harassed Miss Saylor in the past was also present on September 5th to disrupt Mr. Jennings' business. And what better way to disrupt his business than by making it appear that he had served food containing a foreign object to a customer who it just so happens that the protesters had harassed and targeted for years. The manager of Eat More Chicken even heard one of the protesters say that fate had given her an opportunity she couldn't pass up. The protester was then seen alone with the sandwich, just before it was served. This protester served the screw to Bryson Saylor on a silver platter. Members of the jury find in favor of Drew Jennings. Thank you.
All right, 1 minute for rebuttal.
Thank you. The defendant tried to claim that an unnamed protester killed two birds with one screw. But do you see a protester here today? I certainly don't. Did you hear any evidence that someone else did it? I sure didn't. Additionally, the defendant never provided proof of his alleged financial loss. His bird was just fine. It was Miss Saylor that was hurt. The defendant's Hail Mary is far-fetched because, as you've heard today, it was the defendant who had the motive. His ambition, his dream drove him to steal Miss Saylor's business. The defendant had the means. He made sure that no one in the restaurant could have seen him place a screw and had a toolbox containing screws exactly like the one found in Miss Saylor's stomach. And the defendant had the opportunity. Miss Saylor, in his restaurant, innocently ordering her lunch. The evidence supports only one conclusion. The defendant committed battery by placing a screw in Miss Saylor's chicken sandwich. We ask that your verdict reflect this. Thank you.
All right, thank you, everyone. If we were doing this live, I think at this point we'd take a break and the scorers would go into deliberations and deliver our scores. But since we're doing this on Zoom, I'm not sure exactly what we're supposed to do. Of course, the scorers and the judge usually critique everyone and give them some useful tips. I guess.
Yes. Your Honor, the scorers may need a few minutes to
Right.
Submit their ballots electronically.
Do we just?
She doesn't know. All right, so at this time, we're actually going to ask the jurors to exit this Zoom and join the Zoom meeting. They should, for juror deliberation, they should have received an invite for that from Stephanie Vonamy. If you didn't receive the invite for that Zoom meeting, just send me a private message or you can email Stephanie for that link. So we'll be opening the juror deliberation now. But please make sure you exit this one first. And everyone else, if you all would like to take a 10-minute break, and we will be back. Thank you so much, Justice Page.
I think I'll come back in 10 minutes. Thank you.
Nobody moved any of the clock.
Not on me. We want on me.
All right, our jurors have finished deliberating and they will be rejoining us shortly.
Yes.
So I think the way we're going to handle this, Your Honor, is we would like you to give your feedback, and then we're going to ask our scorers to introduce themselves, and we will deliver the verdict, and then we will announce the winner of the 2021 competition.
All right, I'll be happy to start. I just want to thank all the members of the YLD for participating in this first, because according to my weather app, it was a pretty day across the whole state today, and it's been raining a lot on Saturdays. So thank you all for doing this. And I want to especially recognize Terica Smith, who's from Jackson, as our YLD president, and Michelle Sellers, our TBA president, both from here in Jackson. The participants, I'm always just blown away by how good you are. And every time I do this is my third time, I think, to do the finals. It's just a little bit better. But I'm just so impressed. I think all of you could be lawyers in 7 or 8 or 9 years, however long. I'm sure not all of you are seniors, but I hope at least some of you will be appearing before our trial judges and appellate judges across the state in just a few years. I will say that presiding over this, it's the first time I've had a Zoom trial, and I was a little handicapped when the judge is in person. I can kind of read body language and all that stuff, and I couldn't do that. And I know it probably seemed like maybe I was ruling against particular lawyers or a particular side, but when I was trial judge, it was always nice at the end of the day if each side had won about half the objections, but you can't always do that. But I will say that I felt a little rusty. It's been about 10 years since I presided over an actual trial in the circuit court here in Jackson. And then my colleagues on the circuit court told me I was demoted to the Court of Criminal Appeals. And then those judges told me I was demoted to the Supreme Court. So let me again say how wonderful you all are. Everybody just did a fantastic job, and I really appreciate it. And I wish we could have done this in person so I could have met all of you and seen all of you, but at least we got to do it this year, so that's progress. Congratulations to all of you. Now,
Thank you, Justice Page. Thank you, Justice Page. You got it.
There you go.
Okay, thank you. Thank you, Justice Page, again. I'm sorry. So much technology and we're trying to manage it all. Again, I'm Terica Smith. I am the president of the TBA Young Lawyers Division. I am an assistant district attorney in Jackson. I would like to say, students, you did a marvelous job. Thank you for your very, very hard work. And I'm going to go around and ask that our jurors introduce themselves. And I will start with Tasha.
Good evening, everybody. I'm Tasha Blakeney. I am Zooming you from Knoxville. And I am the vice president of the Tennessee Bar Association and a former president of the Young Lawyers Division. So I used to hold the position that Terica holds now. And so that means that I have worked in some capacity with mock trial for many, many years as a coach, as a volunteer, as a scorer, as a presiding judge, you name it, and as a parent now of a daughter who went through all 4 years of high school participating in mock trials. So I just want to congratulate both teams. I'm just very excited to watch the caliber of the competition, and I'm really, really proud that one of you will will represent us at the national competition. So congratulations to all of you and to your coaches and your parents, your families, and all the people who helped you get where you are. Thanks for a great competition.
All right, Quentin, if you could introduce yourself next.
Well, good evening, everyone. My name is Quentin Thompson, and I am in Memphis, Tennessee right now, and I work for Morgan & Morgan, so for the people. I am a plaintiff's attorney, so I have not dealt with the case quite like this, but if I do, I know who to come to and ask questions about my theory of the case. But I just want to say you all did a great job. I used to participate in this competition in high school, and then I did mock trial in college and law school, and you all are some of the best I've ever seen. And I'm also the current president of the Ben F. Jones chapter of the National Bar Association and the Young Lawyers Division for the Memphis Bar Association. But I'm happy to be here tonight. Great job, everyone.
Okay, Troy, all the way from Mexico.
Yeah, good afternoon, good evening to all of y'all. My name is Troy Weston. I am a former attorney, so I practiced law for about 12 years with Tasha Blakeney in Knoxville, Tennessee. I was also primarily a plaintiff's lawyer, not exclusively, but I did a lot of plaintiff's work. I am now a U.S. diplomat who is assigned to Ciudad Juarez, Mexico, so I'm coming to you from Ciudad Juarez, Mexico. I also, in terms of bar association experience, I'm a former president of the Young Lawyers Division, and I spent 2 years as the chair of this competition way back in 2012 and 13. I'm always so impressed with the caliber of the competition, and I want to tell you all that I thought you did a great job, and I'm happy to give more individualized feedback after we have adjourned for the day if anyone's interested in that. But you all did a terrific job, so congratulations.
All right, Brittany, you're next.
I am Brittany Faith, and I'm currently the vice president of the TBA-YLD, which eventually comes into the presidential role. So in 2 years, I'll be the president. I am an immigration attorney out of Chattanooga, Tennessee. So my clients may be in front of Troy at some point. And so I am a big fan of Build a Smalls. And so I am very happy to see all of you here tonight. I don't personally do this a lot. I do occasionally go to immigration court, but it's not a lot. And it's kind of a different process. The rules of evidence do not apply in immigration court. So I'm always happy to judge mock trial and actually see the rules of evidence again and see what a wonderful job you do. And I've just was blown away, especially with how quick you guys are on your feet, how you guys can, make your objections and respond so quickly. And when your witness doesn't respond exactly how you want to, I just think that you guys did a masterful job of that. And you all should be very proud.
Joycelyn, could you introduce yourself?
Sure. Hi, I'm Joycelyn Stevenson. I'm the executive director of the Tennessee Bar Association. Prior to this role, I was in 16 years in private practice doing employment discrimination work at 2 law firms here in Tennessee. I'm very proud of all of you. What a wonderful job you all did. Congratulations on a great accomplishment. When you go to law school, please join TBA. We'd love to have you come back and help us with this competition in the future. So take care and congrats again.
Judge McVeigh, ready? Judge McVeigh, you're up next.
Hey everyone, I'm Alex McVeigh. I'm a General Sessions Court judge. I recognize some people on here from an earlier round a few weeks ago. Again, I'd like to say that this round was the first time in the last, 8 years I've been judging mock trial that actually even the preliminary statements, the preliminary issues set the tone for an amazing round. Just the way in which you utilize technology, one of the teams, and also just the way in which you both presented yourself, even in those, couple preliminary matters, Your Honor. It just set the stage. I'll also say, I don't know if it's because of this problem, but the lawyers often get all the credit. I will say in this round, like in some of the others, I want to just give some props to the witnesses who were outstanding and don't get a lot of credit far too often. But I think this, compared to any of the years I've remembered in the past, this year's witnesses were absolutely amazing. So great jobs. I hope you, if you're not considering law school, I hope you're considering a career in drama or the arts whenever you go off to college, because you all were awesome. as well as the lawyers. Great job, guys.
David, if you can introduce yourself.
Hey everyone, my name is David Jones. I am out of Nashville, Tennessee. I am I'm an assistant district attorney here in Nashville. I am also the president of the Napier Luby Bar Association. That's an affiliate of the National Bar Association. Let me just say, as a prosecutor, I'm in court a lot. You all did a tremendous job. I was very impressed. I want to echo the sentiments of everyone here. Please try to go to law school. And if not, go into acting, because some of your performances were very believable. And I was very intrigued. So you all did a great job. And I will say that the performance that I saw tonight, you all can be in any courtroom, it seems like. So just stick at it, and good luck to the winner. Even the one who doesn't go on to the Nationals, hey, keep at it, because you all did a tremendous job. Thank you.
Okay, John Anthony.
Good evening, everyone. My name is John Anthony Carreras. I'm in-house legal counsel for Memorial Healthcare System. So my practice area is mostly corporate healthcare. And I have to say, I went to undergrad at the University of Florida. So even though I am an honorary Tennessee native, I still bleed orange and blue. And then I went to law school out in Colorado at the University of Denver. Happy to be here, honored to be, a juror in this competition this evening. I think I can agree with all the statements that have been made about how well you guys performed. One thing, I'll keep it brief. One thing I will say is you guys give me a lot of hope in the direction of the future of our legal profession. And I'm glad to know that a lot of you are considering law school. Thanks. Great job, everyone.
All right, Justin, if you could introduce yourself.
Sure. Good evening, guys. I'm Justin Faith. I'm the treasurer of the Young Lawyers Division here at the TBA. So normally I deal with the food reimbursements and the hotel reimbursements and all those fun logistical things that we have, but we don't have that now this year with being virtual. So my job has been a lot easier. So I appreciate that. Thanks, guys. I practice business litigation at Gearheiser Peters, Elliott & Cannon in Chattanooga. And I thought you all did an excellent job. It was a very good competition, and I don't have anything else to add. I know it's getting late, so good job, guys.
And I'll ask that Billy introduce himself.
You're muted, Billy.
Hi, everyone. My name is Billy Leslie. I am the TBA YLD president-elect, which means I'll be president next year. You all did a fantastic job. I am currently Associate General Counsel at the Department of Commerce and Insurance for their Securities Division. So I don't get a lot of courtroom experience as far as this kind of stuff goes, but you all did a fantastic job. So kudos to you all. Thanks for sticking with us this weekend and last month as well. But great job, everyone. Have a great night.
Okay, so now we've come to the part that I know you all care the very most about, is how this all turned out, right? Okay, so we have two announcements. The first will be the verdict. This is which, did the plaintiff carry their burdens, okay? And the jury decided that the plaintiff did not and rendered a verdict for the defense, okay? But the part that you all care the most about is who won this competition, right? And we're going to announce that tomorrow. I'm kidding. I'm kidding. Okay, the winner of the 2021 mock trial competition is GPS. Congratulations. Thank you to all the teams. Thank you to all the attorneys. Everyone did a marvelous job. Congratulations. Good night.
I'm going to get a chicken sandwich.
X-rated
Bye, everyone.
Bye-bye.